Welcome, everyone, to the Wizard of Radical Self-Respect. My name's Jared Mello, and I'm the Shepherd of Black Sheep. Welcome, everyone that's in the chat here. Tim, Miss Kim, Kat, D, Bella. I wasn't even sure if I was going to go live tonight, but I decided there's enough material to talk about here, which we're going to change the topic, clearly, to going over the Kouri Richins verdict that happened the other day. Nope, I'm here now, Miss Kim. Everyone can see me now, I'm sure. But how is everyone today? Tim's got it. Tim's right. But Kat, how are things across the pond? D, how are you? Tim, what's the score to the World Baseball Classic? Let's see. Last I saw, it was tied. Bethany, welcome. Bethany's like Katy Perry. She's wide awake. Oh, man. USA lost 3-2. Venezuela. What do they call it? Maduro's revenge. Laura, welcome. Oh, my goodness. Sydney, how are you? There you go. Nothing like being hooked on the Wizard of Radical Self-Respect. Charity, welcome. Glad everyone's here, even though I started later than normal. For those of you who are new, I usually start a little around 10 p.m. Eastern, but today, clearly, much later. So we're going to go over a Lawyer Lee video first, 3 lies that cost, because from what I'm learning about the case, I haven't looked that much in depth to it yet, but I'm slowly but surely learning. It seems like her defense kind of let her down a little bit too. Now, that doesn't mean she's not guilty. Doesn't mean she didn't do it. But I also think her defense let her down a little bit. But we're going to go over her, and then we're going to go over JD, a lawyer explains. And what else? And another new person. I'm sure some of you know this person, but the Emily Show. Yep, she was certainly found guilty, that's for sure. But let's see what we got here in this. These are 3 lies that Lawyer Lee's about to go over. Make sure you check out Lawyer Lee's channel. Try to say that 3 times fast. Subscribe to her work, support her. And while you're coming in here, make sure you like this video. Montana, welcome. I also like that guy, JD. JD seems to have some good breakdowns too.
In the Kouri Richins murder trial, prosecutors have introduced a lot of evidence, but 3 specific statements they say were lies may end up haunting Kouri Richins more than anything else. None of these alleged lies has anything to do with fentanyl, and none of them proves that Kouri poisoned her husband. But in a trial, lies can be incredibly powerful because once a jury decides someone has lied, they start to question everything the person said. So today we're going to look at each of these 3 statements and ask 2 questions. First, does this actually help prove murder? Or,
and here's the other thing. I think Kouri could have done it, and her defense team didn't do a good job. I think both of those things can be true at the same time. Guilty, she did it, but also her defense team didn't do a good job.
At least suggests that Kouri had a motive to murder her husband, Eric. And second, even if it doesn't directly prove murder, how much could it influence the jury? So in each of these cases, we have evidence that suggests Kouri lied to someone close to her, like her husband or a friend, or to a bank. And with each of these lies, it's not just what she said, it's also why she said it that matters so much. Now, in a trial, like I say, lies are incredibly important evidence. As a trial lawyer, you are always on the lookout for any time the other side.
So the sentencing is going to be on Eric's birthday, actually. Kind of poetic that way. But what I heard was 25 years to life minimum is what she's facing. And the whole thing about the sentencing will be whether there's the possibility of parole or not, but it's a mandatory minimum of 25 years in Utah. So it's going to be 25 to life, no parole, or 25 to life with the possibility of parole. Those are the options from what I can see.
Lies because that makes for the best cross-examination. A mentor of mine used to say, better one bad lie than 10 good facts. So let's dive in. Lie number one has to do with the Valentine's Day text to her husband, Eric. It was Valentine's Day, and Kouri was spending it with her lover, Josh Grossman, not her husband, Eric. To make matters worse, her husband was not only alone on Valentine's Day, he was extremely sick. And in her text messages, Kouri lied to her husband about where she was. Now, let's lay out a little context around these extremely important messages. The prosecution alleges that Kouri tried to kill her husband more than once. According to the charges, Kouri tried unsuccessfully to poison him on Valentine's Day when she gave him a poisoned sandwich from a local diner. Now, it didn't work. And in fact, prosecutors say that is what prompted her to ask for a stronger drug when she got a refill from housekeeper Carmen Lauber. Now, according to prosecutors, it was that stronger stuff, what she called the Michael Jackson stuff, that actually killed Eric on March 4th. There is a lot of question around whether what Kouri bought was fentanyl. And since Eric died of a fentanyl overdose, that's a really important question. But that's not our topic for today. The text messages we are talking about today show that Kouri texted her lover, Josh Grossman, on Valentine's Day, telling him she loved him. She asked him to be, quote, one of her Valentines. And she drove an hour to see him and to spend the day with him. She sent a map so he could track her as she drove up to visit. In stark contrast to Josh Grossman, Kouri's husband, Eric, spent Valentine's alone and sick. Prosecutors say that sandwich from the local diner had been poisoned by Kouri after she purchased it. There have been no specifics offered as to how that was done. Here is the back and forth text message exchange between Kouri and Eric on Valentine's Day. Eric, K, which I assume means Kouri, I'm going to go lay down for a bit. If I don't start getting better, I'm going to head to the hospital. And Kouri says, geez, it's that bad? Need me to come home? Go to take a nap and call me when you're up. And Eric says, are you home? And Kouri says, no, in Provo, waiting for my cabinet installer guy. Are you home? And Eric says, in the office, I've been sleeping out here. Kouri, weirdo, go in our bed. Eric, okay, wish you were here. Kouri, I would cuddle you. Heading back in 20, he just got here. Now, what Kouri tells Eric, that she was waiting for a cabinet installer guy, that's false. She was an hour from home spending the day with her lover, Josh. Later, Eric told friends that he thought Kouri had poisoned him with the sandwich she brought him from a local diner. So far, the jury has had direct testimony about this from one.
And that was the first attempted murder there. Imagine that. I mean, all of this was to get money out of the entire thing and then maybe run off with this other guy. But there's another phone call, for example, where she's bragging about getting $11 million in real estate from what is something with 250 grand that she did and turned it into 11 million. Like, that's just how money hungry she was. And her arrogance and hubris to write that children's book afterwards too. Just absurd.
One person, Kouri's friend, Allie Staking. But Allie said that Eric and Kouri both seemed to think it was a joke that Eric thought this, and Allie was visiting the Richins about a week after the Valentine's Day incident. Here's what she said about it.
You were talking about when Eric got sick from a sandwich, right? You talked about that with Mr. Bloodworth.
I did.
And he told you, what did he tell you?
That he believed that Kouri had tried to poison him.
Okay. Did he tell you, I believe Kouri tried to poison me, or did he say to you, did Kouri tell you she tried to poison me?
No, he said, he said Kouri tried to poison him.
All right, and who was there? Kouri was there?
Yes.
And what was her response to that?
She was laughing and she said that's not what happened.
And what did happen?
I don't know what happened.
Well,
He took a bite of the sandwich and got an allergic reaction and had to shoot himself with an EpiPen.
okay, so they talked about that there was an allergic reaction.
Yes.
Was everyone laughing?
Yes, we were all laughing and we jokingly said, "Don't eat what Kouri feeds you."
Okay. And did Eric appear upset about what had happened prior with the sandwich?
No,
Did he seem scared about what had taken place?
no.
How are he and Kouri getting along when you were there that last visit?
They seemed better than I'd seen them in a long time.
So let's ask our two questions. First, does this help the prosecution prove that Kouri murdered, or maybe more precisely, attempted to murder Eric? I think the answer is that it doesn't help a lot. Maybe some, but not a lot. Kouri did something that millions of people do every day. She picked up a meal at a local restaurant. It wasn't even something that she made herself, and she took it home to her husband. So the fact that Eric thought he might have been poisoned, that's not proof that Kouri did it, especially if this was just a joke and they were laughing about it. But prosecutors do have strong evidence that Kouri was lying to her husband in the text messages, that she was telling him she was working when she was really spending the day with her lover. So here the second question becomes far more important.
So the lies. I mean, and part of a jury also is like how likable / remorseful does the person who is the defendant even seem to be? That contributes, right? Despite of the facts, and despite the fact that's not really supposed to matter, it does matter on a human level.
Will this evidence have an impact on the jury? Kouri is having an affair and easily lying to her husband, Eric, about it. Oh, I'm waiting for the cabinet guy. I'd be glad to come home. I'd cuddle you if I could. There's something about the fact that it was done on Valentine's Day that just makes the betrayal seem even worse. Kouri clearly can lie believably and to people she cares about. Eric knew her well, but he seemed to have no clue about her affair. And if prosecutors are correct, no clue about how deep her financial troubles were. Of course, the defense would probably point out that lying about having an affair is a long stretch from poisoning your husband. But even if the jury can keep all of that straight, they still will be left with a lot of questions about whether Kouri can be trusted. And that creates a problem for her defense. So lie number 2 is Kouri's claim that she had broken up with her lover, Josh Grossman, 9 months before Eric's death. Allie Staking had been close friends with.
Yeah, and all this was on Valentine's Day too, to add insult to injury to the whole thing.
Kouri since childhood. She lived in California, but about 2 weeks before Eric died, she visited Kouri in Utah. As I said, Allie and Kouri were very close, so close that Kouri had confided in Allie about her affair with Josh Grossman. But when Allie came for a visit 2 weeks before Eric's death, Kouri told her something different.
Do you know who Josh Grossman is?
Yes, I know of him, yes.
How do you know of him?
Kouri told me about him.
What did Kouri say about him?
She said that they were having an affair.
And when did she tell you this?
It was about June 20.
Did she tell you the status of that affair when she spoke to you in June 2020?
Could you clarify?
Was it ongoing at the time?
Yes, it was ongoing.
Did she ever tell you that the affair was broken off?
She did.
When did she tell you the affair was broken off?
My last visit prior to Eric passing, she told me that she'd ended things with Josh and chose her family. It had been over for about 9 months at that point.
And was that last visit you had with Eric Richins on the weekend of February the 20th, 2022?
Yes, I believe so.
And she said then that she had broken it off 9 months earlier.
Yes.
But the evidence at trial has been absolutely overwhelming. At the time that Kouri told Allie she had broken up with Josh, that was completely untrue. Eric died sometime late on the night of March 3rd or early on the morning of March 4th of 2022.
He died on my birthday, March the 3rd, or maybe March the 4th.
Prosecution put in evidence that Kouri and Josh had been romantically involved for a year and a half by then, and very much including the months right before Eric's death. In December of 2021, 3 months before Eric died, Kouri told her lover, Josh, that they were in a love triangle. She explained what she meant. Well, I'm married, and you, me, our relationship, I don't know what else to call it. I'm in love with a man that's not my husband. That same day, Kouri wrote, I'll always love you, handsome. If it's okay, can we talk tomorrow? I want to go to sleep as happy as I was when I woke up with you this morning. Kouri told Josh she didn't want to break up her family, but I do just want to love you. I do love you. I love our love too. It's my favorite.
And again, this all just makes her look worse, right? Especially when this comes out. And yeah, this doesn't mean you're guilty of murder, but it certainly doesn't make you look good in the eyes of the court.
The relationship continued hot and heavy up until Eric's death. As I mentioned earlier, Kouri spent Valentine's Day with Josh, not Eric, and 5 days later, on February 19th, Kouri texted Josh, just wanted to say, I love you. That was just 2 weeks before Eric died. 4 days later, on the 23rd, Kouri texted Josh to say she had had a crazy dream. You quit your job, I divorce, and come up with millions and millions. We buy Midway, a house she wanted to flip, and live in the guest house and rent out the huge house as a big event center and hang out every day, raise some kids, have a little farm. In a later email, she added, I've been thinking that dream for weeks. Not possible, but it's fun to dream. Maybe another property when timing is better.
So what does it sound like her ambitions were? Well, to be able to do this, get rid of her husband and be able to live this fantasy out.
Sounds kind of amazing though, right? On the night Eric died, Kouri texted Josh that she hadn't had a second to text, but give me a few, love you. The text clearly showed the relationship was on right before and at the time Eric died. And to cement the point, Kouri's lover, Josh Grossman, took the stand and told the jury that the affair lasted another 9 months after Eric died. So why then would Kouri have told Allie that she had broken up with Josh 9 months earlier? If Kouri had never told Allie about the affair in the first place, that would be one thing. Kouri might have been embarrassed, or maybe she was worried it would get back to Eric. But in this case, Kouri had told Allie about the affair. She apparently was not worried that Allie would spill her secret. So why, 2 weeks before Eric's death, did Kouri suddenly have a need to tell her close childhood friend something that clearly was not true? Well, we'll ask our first question. Does lying to Allie make it more likely that Kouri killed Eric? And I would say maybe not directly, but it is related to what the prosecution says is Kouri's motive. They've talked about...
You hear that? That's important. It's not directly related to the murder, but is directly related to the motive for the murder. And that makes sense.
Financial motive, but obviously her relationship with Josh could also be part of the motive. Maybe she wanted to be with Josh. But lying to Allie, if that's the case, would be a pretty short-term solution because obviously it's going to come out later. Now, maybe she was thinking she could tell Allie that they had rekindled their relationship, even though it had been off. Or maybe she wanted to hide her relationship with Josh so no one would suspect her of murdering Eric. So the second question then, how much is this lie going to impact the jury? The prosecution has charged Kouri with aggravated murder. That means it's not enough for them to show that Kouri killed Eric Richins. For the jury to find Kouri guilty, they have to believe it was intentional. And if Kouri saw a need to lie, to hide the fact that she was having an affair, that opens up the question. Is that because she was already plotting the murder and thinking about how she would avoid getting caught? It doesn't answer the question, but it just gives the jury something more to think about. All right, let's talk about lie number 3.
All right. So before we get to lie number 3, please remember to like the video. Likes are free. Leave your DNA on that like button and subscribe to the channel if you're not already. Come say hello to the flock of black sheep here in the live chat. Today we're going over the Kouri Richins case, the verdict of it. So no Nancy Guthrie today. We might be back to Nancy Guthrie tomorrow. We shall see what unfolds here.
And this is the one Kouri told when she took out a HELOC on her own family's.
Butterfly Girl, thank you very much for becoming a member. I really appreciate it. Becoming a member gives you access to the members-only live streams. Super chats are a great way to support the channel and get questions answered, and so are super stickers.
Home. Eric owned the house that Kouri and he and the kids lived in. Kouri was not a part owner of the home. Eric was the only owner. According to prosecutors, Kouri told the bank that she had authority to sign on behalf of Eric as power of attorney. She took out a loan for $250,000 against the house and put that money into her house flipping business. After Eric died, she justified what she had done to one of Eric's friends, a man named Bryce. And here's the conversation.
Yeah, I took $250,000 off of our house.
Yeah.
Do you know how much in
So she took $250,000 off of the house. Like a refinancing, or refinancing the mortgage, or taking it as collateral or something?
real estate we own today? Because I did that, $11 million worth of real estate. Do you know why I did that, Bryce? Because Eric would never let me work. Eric never trusted me in
100%.
believing me. No, but I want you to know that. Would you do it? Would you take $250,000 to make $11 million?
Well, that's tricky, right? Like, the communication was the big thing for Eric, right?
He told me no, Bryce. I believed in myself. He told me no, but I knew I could do it because I know what I can do. Bryce, I wouldn't do something that I didn't know that I knew I could do. I'm not stupid.
Right.
Bryce, I own 12 properties that are almost all paid off. Including my own house that I've almost paid off. Like, I own multiple houses in Park City.
And this is what narcissistic people do. They twist and distort the truth, tell lies of omission. They just can't be trusted.
Mill Creek, in Saratoga Springs, and Heber, in Midway, and all because I did that. And they all go to my kids, $11 million of real estate property because I took $250,000, Bryce. He just never gave me a chance. He never gave me a chance because he didn't believe in me. And he can say whatever he wanted. He can say I stole from him. He can say whatever. But at the end of the day, that $250,000, Bryce, was paid off in 7 months and turned into $11 million.
From the testimony of the forensic accountant, we know these numbers aren't really accurate. Kouri did not actually own outright $11 million worth of properties. But the far more important allegation is that Kouri signed on Eric's behalf. He told her no, and she did it anyway. She didn't tell him that, and she kept the money for her.
So that's a forgery, signed on Eric's behalf there too. But this is also what narcissistic people do. They exaggerate and lie about their accomplishments. Why? Well, it feeds their grandiose sense of self, for one. And in this case, she wanted to kind of present a case to someone else. Oh, look at how much of a savvy investor I am. I was able to turn that $250,000 into $11 million.
Her own purposes. We've heard testimony, and we heard Bryce say that Eric considered that a real problem, a major betrayal. In her own mind, Kouri had justified it. And as she told Bryce, she thought she had to do that because Eric would not trust her. Like the other two lies, this one has nothing to do with fentanyl. The fact that Kouri took out a secret loan is in no way proof that she poisoned her husband. But this lie, the one to get this HELOC loan, may be the most dangerous one of all for Kouri because it plays directly into the state's theory about motive. The state says Kouri wanted, that she needed Eric's money for her business. Now, if you listen to Kouri's words to Bryce, she seemed to be past the need for money when she was talking to him. She was talking about success, about owning properties and building something valuable for her children. But when the forensic...
Now, people someone saying in the chat, this is about misogyny, this case. And I would say, no, not this case. Of all the cases, I don't think this is the case of it.
accountant took the stand, we heard a very different story. According to the numbers the forensic accountant reviewed, Kouri was actually in deep financial distress. And when Kouri spoke to Bryce, she admitted what she had done, that she signed on Eric's behalf to take the HELOC, and she used that money to fund her real estate deals. At least at the time she did it, she clearly believed she needed that money to make her business work. And that's where the prosecution's theory comes in. They say this wasn't just risky business dealings. It shows how much pressure Kouri was under and why Eric's money mattered so much to her. Lies are incredibly powerful in a trial. So what do you think? 3 different statements the prosecution says are lies. Which one of these is most likely to matter to the jury? Is it lying to Eric on Valentine's Day? Is it lying to her friends about the affair? Or is it lying to the bank and signing on behalf of Eric to get the HELOC? Let me know what you think in the comments.
So it's the HELOC loans where she got the 205. They're all bad. They're all bad to me. But what do you think? Which lie do you think that she told that was the worst? So we're going to watch a couple of these because this guy I find pretty interesting. The fastest way to lose a jury. I liked this video.
Stay with me. I'm going to give you the secret to why evidence may not matter in the Kouri Richins case.
So this is JD, the lawyer explains. I like this channel. I think he breaks it down pretty succinctly and concisely, and it's easy to understand.
Stay with me. I'll get right to it. Hi, Tony DeWitt here, Missouri appellate attorney, retired. This is a trial channel. No legal advice is given, and everything that I say pretty much is my opinion unless stated otherwise. The Kouri Richins case out of Utah centers on a wife accused of killing her husband, Eric Richins, in March of 2022 by allegedly giving him a fentanyl-laced drink, specifically a Moscow Mule. Prosecutors say the motive was financial, life insurance money, debt, and control of his estate, and they also allege an earlier poisoning attempt. After his death, Richins wrote a children's book about grief, then was later charged with aggravated murder and multiple fraud counts. Today, I want to talk about something that most people never think about when they watch a trial. Jurors are not just judging the witnesses and the facts and the evidence. They're judging the lawyers, too. There was an interesting study done at looking at hundreds of jurors after federal trials. Researchers asked those jurors about their impressions of the attorneys in the courtroom, how credible they seemed, how prepared they were.
And again, this is important. This all matters, right? The more credible that you find a lawyer, and sometimes even the more likable you find a lawyer, the more likely you're going to get a favorable outcome. And again, shouldn't be that way, but humans are going to human. But please remember to like the video. I hear we're dangerously low on likes around here. So slap that like button and make sure you subscribe to the channel if you're not already.
Whether they appeared sincere and whether they seemed trustworthy. And what the researchers found was something that every trial lawyer eventually learns the hard way. Juror perceptions of the lawyers were correlated with the verdicts they returned. In other words, they weren't just deciding the...
Did you hear that? The jurors' perspectives of the lawyers actually had a big impact on the verdicts that were returned. Not surprising to me.
Case on the basis of the best evidence. They were also deciding which lawyer they trusted. And that leads to a really important point about trial practice that people outside the courtroom often miss. If a lawyer loses credibility with the jury, the damage can spread to the entire case. Now think about the position jurors are in. They sit through days or sometimes weeks of testimony. They hear experts, they hear investigators, they hear accountants, neighbors, friends, technical evidence from phone specialists, and all kinds of things. Most of it's complicated, much of it conflicts with one another. There are things that come in from the prosecution, and there are things that come in from the defense, although not always. As in the Kouri Richins case, they didn't even put on a defense. So jurors do what human beings naturally do when faced with a lot of information. They look for a way to categorize it. They look for someone they can trust to explain the story to them. Psychologists who study jury decision-making call this the story model. The idea is that jurors organize all the evidence they hear into a narrative that explains what happened.
Well, that's a good question there, Sarah. On my channel, I just haven't talked about it yet. I haven't talked about Kouri Richins, and so maybe my audience doesn't want me to talk much about Kouri Richins. We shall see.
And once that story begins to form, jurors start asking themselves a simple question. Which lawyer is telling me the story I believe? Now, here's where things can go wrong for lawyers. If a lawyer misrepresents facts, exaggerates evidence, or says something that jurors later realize isn't accurate, the jurors may start to doubt that lawyer's credibility. I'll give you a good example, and that is Kathy Nestor talking about some purported gay relationship that Eric Richins had.
Did you see the text around this text?
I did.
So you have reviewed the text between Eric and Bryce?
I don't know. I don't know that this is a text from Bryce. I have no idea. This does not.
So even how the lawyer is going to present herself to him here just doesn't really look good. Doesn't really make her likable. Comes off as hostile and antagonistic.
Identify Bryce.
So now,
and like she's trying to twist and distort things a little bit.
Identify anybody.
Now that you have your memory refreshed, do you remember seeing this text between Eric and another individual saying that Kouri and I are starting an open relationship tonight? Right?
It says, Kouri and I are starting an open relationship tonight, so I told her I'm taking you home.
Right.
Yeah.
Okay. And you left that out of your report.
No. This would be part of my report.
Did you see sexting between Bryce and Eric when you looked at their texts?
I don't recall that, no.
Katie?
And is this sexting? I don't know what you mean.
No, I'm not talking about this one. I'm
Okay.
talking about other ones.
All right. I don't recall. I'm talking about many hundreds of thousands of messages in this case. I can't recall them all.
Can I show you this other text right here and see if this refreshes your memory? Do you remember seeing a whole bunch of emails like this or texts like this between Eric and Bryce?
They're calling this the Brokeback Mountain lie because they were trying to make it seem like Eric was gay.
Honestly, no, I don't remember. Like I say, there were hundreds of thousands of messages in this case. I don't remember even 1% of them. As I look at this, it just makes me laugh. It doesn't appear to be serious.
So how many of these joke sextings did you review that Eric did?
I don't understand this to be sexting. I think you're wrong about that. I resist your characterization.
Just sending,
Sort of like how, what's his face? Alan Jackson was saying, print that. I'm going to start saying that now too. I resist your representation. I resist it.
text messages to a guy pal that were probably a little off color, but which by no means was a Brokeback Mountain moment. And when credibility goes, a lot of other things go along with it.
That's what they say, Kat. They say when women like older men, what they really mean is they like the Benjamins older men. Perhaps that's a joke that maybe English folks wouldn't get because do they know what the Benjamins mean in England?
You see, I think she lost the jury right there. Jurors may begin to question the arguments that the lawyer makes later in the trial. They may discount the lawyer's interpretation of the evidence. And in some cases, they may begin to distrust the entire narrative being presented. Trial lawyers sometimes say when this happens that the lawyer has lost the jury. And once you lose a jury, it's extremely hard to get it back.
Correct. He's very correct about this. And Dee made a very strong point. Shadow, the night owl, is suffering from, I don't know what he's suffering from, but he needs some CPR, and likes will help him out. So help out Shadow, the night owl, please.
Now, this idea that misleading a jury can affect the fairness of a trial is not just something psychologists talk about. It's something courts have recognized for decades. There's a United States Supreme Court case called Napu versus Illinois from 1959, a little old. In that case, the prosecution allowed testimony to stand even though the prosecutor knew the testimony created a false impression about the witness's credibility. The Supreme Court reversed the conviction and said something very important. The court held that when the state allows false or misleading testimony to influence a jury's assessment of credibility, it violates due process. Why? Because juries rely heavily on credibility when they decide cases. There's another Supreme Court case called Alcorta versus Texas from 1957 that makes a similar point. In that case, a witness gave testimony that was technically true, but misleading because important facts.
And that's the other thing, though, Bella. If they really thought that Kouri was guilty and then they were not going to give her the best defense, it's like, why aren't you going to bring witnesses? So I feel like she could have had better representation. Again, that doesn't mean she's not guilty, but she still could have had better representation, it sounds like.
Had been withheld. Those facts related to the witness's relationship with the victim, which was directly relevant to motive. The prosecutor knew the testimony created a false impression, but did not correct it. The Supreme Court reversed that conviction too, and the court made clear that misleading testimony can distort the jury's ability to evaluate the evidence fairly. So the legal system has recognized for a long time that misleading a jury about facts or credibility can change how jurors interpret the entire case. But even when the behavior does not rise to the level of constitutional misconduct, it can still have powerful effects inside the jury room. Jurors pay close attention to how lawyers behave, and they notice when a lawyer seems disrespectful or respectful. If a lawyer is disrespectful, for example, to a judge, or is disrespectful to a witness, or is snarky with a witness, that has an effect. They notice whether a lawyer appears prepared, ready to cross-examine, or whether they just repeat the state's case on cross-examination. They notice whether a lawyer seems sincere.
And that's tough sometimes for a lawyer, right? Sincerity. I think it's easier for a prosecuting attorney to sound sincere than a defense attorney a lot of times. What do you think? Who do you think is able to sound more sincere? Defense lawyers or prosecutors? Press 1 if you think defense lawyers. Press 2 if you think prosecutors.
And they especially notice when a lawyer appears to stretch the truth. In fact, experienced trial lawyers will tell you something that sounds almost like folk wisdom. Jurors forgive mistakes. They will forgive a lawyer who stumbles over a question. Heaven knows I've done that. I do that on the channel all the time. I just cut it out so you don't see it. They will forgive a lawyer who forgets a document or misstates a date. But jurors rarely forgive outright dishonesty. If jurors believe their lawyer intentionally misrepresented something, that lawyer's credibility may collapse. And I believe that sometimes affects cases in more ways than you know. In fact, I think in the Faust case that we had on the channel almost a month ago now, the lawyer for the defendant in that case made significant misrepresentations of fact, and I think that in some ways made up for complete clarity on the DNA. And when credibility collapses, the jurors begin to view everything that the lawyer says with skepticism. Now, here's something interesting. Psychological research suggests that persuasion often depends heavily on what is called source credibility. That simply means people are more likely to believe a message when they trust the person delivering it.
That's very true. People are more likely to believe a message when they trust the person delivering it. Absolutely true.
So if the preacher tells you something and you trust the preacher, you're likely to believe that. But if the guy who cheats at cards every week when you play with him tells you something, you're liable to think, well, that might be true, and then again, it might not. If jurors distrust a lawyer, they may reject that explanation, even if the underlying evidence might support it. And this helps explain something that trial lawyers worry about constantly. A lawyer's behavior in the courtroom affects not only how jurors view that lawyer, but how the jurors interpret the entire case. Now, there is a somewhat uncomfortable truth here. Legal scholars have pointed out that improper arguments, things like exaggerating evidence or appealing to emotion, sometimes persist in the courtroom because they can be persuasive. In other words, they sometimes work. That's why appellate courts spend so much time reviewing things like improper closing arguments or misstatements of evidence. The courts are trying to determine whether the conduct affected the jury's verdict. Because once a jury has been influenced by misleading information, it can be very difficult to know exactly how much damage was done in that process. But from a practical standpoint, most experienced trial lawyers understand a simple rule. Never argue something the jury knows is not true. For example,
it's a good rule. Never argue something that the jurors know is not true. Seems logical enough. Seems like common sense. But sometimes common sense is a superpower in this day and age.
Arguing that Eric was gay. For example, arguing that there was a tryst going on in the business when the business is operated out of the home of Eric Richins, and it's supposedly with an employee who happens to be male when they're just actually hunting buddies. Those kinds of things can damage a lawyer's credibility beyond belief. The moment jurors believe a lawyer is being dishonest, the jury may stop listening to the lawyer entirely after that. And when that happens, the lawyer has done something very dangerous. The lawyer has shifted the jury's focus away from the evidence and on to the lawyer's credibility. And that is a fight no lawyer ever wants to have in front of 12 jurors. At the end of the day, jurors are not just deciding whether a witness is telling the truth. They're also deciding whether the lawyers are telling the truth or asking them to tell the truth or asking them to tell a partial truth in service of a misrepresentation. Once jurors decide that a lawyer cannot be trusted, the verdict may follow right behind that conclusion. And I think you'll see some of that tomorrow in the closing arguments, and you may see some of that tomorrow, sadly, in the verdict.
Well, and that's what we're going to go see next, the closing arguments from the prosecution and the defense.
Thanks for watching. Thanks for watching.
So now, prosecution's closing arguments. Prosecutor destroys defense.
Pulling out. Let me tell you something. Brad Bloodworth knows a thing or two about juries. I'll have more in just a moment. Hi, Tony DeWitt here, Missouri appellate attorney, retired. This is a trial channel. No legal advice is given, and everything that I say pretty much is my opinion unless stated otherwise. If you're this far along in the case, I think it's pretty safe to say that you don't need me to recap it. but this is the trial of Kouri Richins. She's charged with murder. Wendy Lewis gave the closing argument for the defense, and now Brad Bloodworth gets to get up and go to work in rebuttal. Brad Bloodworth, or more properly, Bradley William Bloodworth, has more than 2 decades of trial experience in criminal law. He spent over 23 years in courtroom practice, prosecuting serious violent.
What a name for a prosecuting attorney. Bloodworth. He's out for blood.
Crimes, including murder, special victims unit assaults, aggravated assaults, gang-related offenses, drug trafficking cases. Interestingly, and something you may all appreciate, he has worked on both sides of the aisle during his career, having experience as both a prosecutor and a defense attorney. That dual background often shows up in trial style because the lawyers who have tried cases from both perspectives tend to understand how juries perceive arguments from each side. And this certainly showed up in his rebuttal closing, and he opens it with a little bit of masterful judo, and it shows up in the way he handled an image that was shown during the defense's opening statement.
Parlor tricks are not legal standards.
I need to point out that the reason this is so masterful is because the defense came in the opening statement and said, look, there are 2 ways to looking at this picture. If you look at it one way, there's a young lady facing away from you. And if you look at it another way, there's an old woman sitting there with a feather pulling out of her head. And that, somehow that means that the evidence is apparently equal. He defeats that suggestion pretty quickly here.
Legal standards are what matter. Let's review a couple of the important ones. You'll have them in your instructions when you go back to deliberate. Reasonable doubt.
Notice that he's letting these slides do the talking for him here. Instead of rushing in and reading these slides to the jury, he is actually respecting the jury's intellect by letting them read the slides to themselves. And this is a very effective presentation technique, and it certainly is effective here.
I come back to this one again and again. Evidence usually consists of testimony and exhibits presented at trial. What the lawyers say is not evidence. I've come back to this slide in rebuttal precisely because of defense's closing. There is a reason the state provided you in its slides with the cite to every single piece of evidence it argued. We told you what transcript page and line number. We told you what exhibit number. Because what the attorneys say.
And even his tone of voice, it sounds more assertive, more confident, more commanding than the defense teams.
Doesn't matter. The evidence is what matters. And there's a reason defense counsel didn't cite you to the evidence. Next slide, Scott. A lot of the evidence is circumstantial. It is. People do not video themselves poisoning their spouse. But circumstantial evidence is just as good as direct evidence. You can use circumstantial evidence to conclude facts just as you can use direct evidence. The instruction gives the example of it is wet outside and people are closing up their umbrellas. That makes sense. Let me put it to you a different way. Does everybody know what happened here?
I love the fact that he has a sense of humor. If you saw this in real time and didn't bust out laughing when you saw
when the feces hit the whirligig. I've never heard that expression before.
it, it's such an effective way of making the point that you don't have to be there when the feces hit the whirligig, so to speak, to understand where the feces land. And I just thought this was masterful.
Kouri Richins chose Carmen Lauber in part because she had control over her. She could help her out. She employed her to some measure. She could help her out. Little quid pro quo. You give me some drugs, I can help you out with your drug court. Kouri Richins chose Carmen Lauber, not me.
And correct me if I'm wrong, chat. Didn't they get the person that gave the drugs to Kouri to testify as well? I believe they did.
Her testimony is corroborated. If you only believe Carmen Lauber's testimony that is corroborated, that is plenty of proof to convict. She was only at that Maverick in Draper 3 times. That's what the digital evidence shows. Each of the 3 times she was there, so was Robert Crozier. Those were the only 3 times he was there.
I don't know about you, but I loved the line about Kouri Richins chose Carmen, not me, because it's true. The reason that Carmen is in this case is because of Kouri Richins, not because of anybody else. The state didn't go out and recruit a snitch. And I think that's really important. And I think he made a good point, and I love the way he's putting this information up on a slide. And basically, it's like the line from the song Alice's Restaurant, you know, with circles and arrows.
Alice's Restaurant. I wouldn't have expected an Alice's Restaurant reference in this, because you can get anything you want at Alice's Restaurant. Walk right in. It's just around the back, half a mile from the railroad tracks.
And paragraphs on the back of each one explaining what each one was to be used as evidence. This is the guy.
Consciousness of guilt is evidence of guilt. Kouri had a guilty conscience. She couldn't talk to her father that night, not because she was overcome by grief, because she could not face the man whose son she had just murdered.
Over and over and over again, he returned to the theme of this is what the evidence is, and this is why it matters. She said she couldn't face Mr. Richins. And the inference from that he's drawing, which is not necessarily evidence, but it is a reasonable inference from the evidence, is that she feels guilt. Knowledge of guilt is what's keeping her from doing that. She's probably afraid she can't keep it together and convince them that, you know, such a tragedy happened. Because I'm pretty sure even at this point, they already suspected that something bad was going to happen or could possibly happen to Eric. And so, like I said, over and over and over again, he just did the same thing. But I'm going to let the last little part of this play out, because I thought the end of this closing was probably one of the best ones I have ever seen.
Wow, how about that? Make sure you like the video here, folks. Shadow the Night Owl is really struggling. He's actually struggling to stay awake right now. Likes will help Shadow the Night Owl stay up. So remember to like the video, subscribe to the channel if you're not already. Becoming a member supports the channel and gives you access to the members-only live streams. Super Chats, great way to support the channel and get questions answered. Super Stickers, great way to support the channel too. And thank you for all the support I've been getting so far. The last couple months have been my best couple months so far, so I'm very grateful for it. I'm hoping to keep it going.
And it truly was masterful. And if it didn't make you laugh a little bit too, well, then you're probably not breathing the same air I'm breathing. So watch this and enjoy seeing a master at work.
In defense's closing, when you strip out rhetoric that could be argued at any closing, anytime, anywhere, on any case, when you strip that out of defense's closing and you hone in on substance, the entire substance of the defense's argument is based around trying to explain the walk the dog letter. Kouri Richins is saddled with this letter and needed to craft the defense
The walk the dog letter, that was a big one. We'll probably go over that soon too.
around this letter. It's obvious that the letter was written to get her brother to testify to a narrative that would explain everything. Let's unpack the letter in about 15 or so sentences, not with what Kouri Richins wrote, but with what the evidence showed. It's a translation from what Kouri Richins wrote to what the evidence shows. First part, here's what I'm thinking, but you have to talk to Ronnie. He would potentially have to testify to this, but it's super short. What the evidence shows is this says, I'm thinking that if you tell Ronnie to testify to what I'm about to write, it will explain.
Yeah, chat, how old is Kouri Richins? Is he late 20s, 30s?
Everything, and I will not get convicted. Ronnie will need to tell this to my lawyer because I just made it up and it will have
So she's 35.
to come from him. Never mind that I was arrested 4 months ago.
So how does a person become a Kouri Richins? That's a good question. I think you are born with some of the startup material to be someone like this. So whether that's the impaired empathy or extreme selfishness, etc., narcissism, you have that startup material. Then your life brings it out of you some more, and you develop entitlement. You develop that lack of empathy gets even worse, and you think you deserve everything your heart desires, and you think rules don't apply to you. She probably has some pretty privilege as well that added to it, added to the entitlement, added to the grandiosity. So this might be the first real consequence she's had for a while. I mean, she was so arrogant that she did it, and then she wrote a children's book about children dealing with grief. Like that's the audacity to do something like that is wild after you did what you did.
I need an excuse for Ronnie and Eric to be hanging out. Never mind that football season ended a month earlier. I need to explain the fentanyl, and fentanyl must be everywhere in Mexico. Never mind that Eric would have to fly with the fentanyl, and I later say that Eric would not fly with drugs for fear of getting caught. Never mind that I know this story despite Ronnie never telling me. I need to explain why everyone will testify that Eric never used drugs.
This is the walk the dog letter here. All of this makes her look terrible, right? Guilty and terrible.
This kind of happened once with THC gummies on a trip to Hawaii. Hopefully this is enough to corroborate my entire walk the dog story. I need to distance myself from fentanyl. These are my made-up words but Ronnie can make up his own words.
For some reason, it looks like she's about to like laugh here or something. I don't know what this is all about. Maybe a duper's delight or something, but I don't know how it would be a duper's delight in this case.
If Ronnie does not say these things, I'm convicted. I need to explain why investigators never found a trace of fentanyl in my home. Never mind that it doesn't make sense that Eric hid the fentanyl after asking me to buy it.
And so again, for people who don't realize what's going on in this case, Kouri Richins was accused of murdering her husband by giving him a lethal dose of fentanyl. And she actually tried to kill him multiple times. But that was the trial. And just yesterday, she was found guilty of this. And she's found guilty also of some other financial crimes as well as the attempted murders too. Guilty on all fronts. And the sentencing is May 13th. And they had 3 kids together. So now the 3 sons, no mom or dad.
Don't get caught passing this made-up story along to Ronnie. That would be horrible. Tell Ronnie to keep the story short so that he does not mess it up. Since his conversation with Eric never happened, tell him that it was only 2 minutes long.
See? Another lie.
Ronnie needs to do this so that I do not get convicted. I can then extract revenge on Eric's sisters.
Extract revenge on Eric's sisters. Sounds a bit like some vindictiveness there. Some Sheriff Nanos vindictiveness.
Remember, I just made this story up, so my lawyer does not know it yet. All the evidence in this case proves that Kouri Richins murdered her husband and the father of her 3 children, Eric Richins. There is no other rational explanation for the evidence.
I agree. I mean, what other rational explanation could there be?
Despite all the evidence, Kouri Richins clings to the facade that has enabled her to get away with so much for so long. And despite all the evidence, Kouri Richins doubles down and blames Eric. She is intensely ambitious. See through her facade, check her ambition. Do not let her get away with murder.
What could I possibly add to that? That was, I think, the reason that the jury was only out for a short time. I had prepared really to be able to take my time doing these videos because I figured being Utahns, they would probably, want to go through all of the evidence to make sure they had everything right before they got to this point. But I think the combination of the lawyers' personalities, the facial expressions of Kouri Richins during the trial, the way that some of the witnesses were treated, and the fact that the evidence can only be viewed rationally in the totality in one story form, and that happened to be the prosecutors. Well, there you go. That's why you wound up with such a short time before the verdict. I'll do a postscript on this, and then I probably won't have any more to say about Kouri Richins, even though Kouri Richins has been very, very good to me because you guys have started following in droves, and I really appreciate that. I hope you'll stick with me. I'll do a lot of other trials this year. One more thing. For those of you who might be inclined to do so, consider saying a prayer for the Richins children.
A fair thing to request.
They now have to live the rest of their lives without their dad, and with the only way to see their mom being through a plastic glass in a prison cell. Those children have a hard road to hoe. And I believe that God hears all prayers and answers all prayers. We may not always like the answer. That's my personal belief. I'm not suggesting you adopt it. But if you are inclined to say a prayer, that would be a
This guy seems really like genuine and straightforward to me, which is why I like him.
wonderful thing to do. And while you're at it, and I know this sounds contrary to the way I have dealt with this case, but say a prayer for Kouri Richins too, that she stays healthy and has a long life in prison so that she can spend every day in intense regret for having done to her children what she did. That's all I ask. Thanks for watching. I appreciate you being here today, and especially if you have subscribed. That means a lot to me.
Yes. Subscribing to my channel means a lot to me as well. So make sure you like the video here. And now we're going to do, well, which one should we do? Kouri Richins' case was defensible, or 3 mistakes that hurt the defense closing. I think we'll do the 3 mistakes that hurt their closing.
I have to give Wendy Lewis credit. She tried very hard to repair the damage, but she didn't get there. I'll have more in just a moment.
And this guy's JD, a lawyer, explains.
Hi, Tony DeWitt here, Missouri appellate attorney, retired. This is a trial channel. No legal advice is given, and everything that I say pretty much is my opinion unless stated otherwise. If you're this far along in the case, I think it's pretty safe to say that you don't need me to recap it. But this is the trial of Kouri Richins. She's charged with murder, and this is Wendy Lewis closing the case for the defense. I thought Wendy Lewis started out very well in her closing argument. And she started it with a story model, which, again, is a very effective way to close out a case. Tell your story. Remember when I talked about reasonable doubt, the 2 stories metaphor. Is the prosecutor's story more believable than the defense's story? So she tried to make the defense's story more believable. Every lawyer wishes that in every trial that they try, that they could file a timely motion to change the facts. But unfortunately, you cannot file a timely motion to change the facts. And so you're stuck with the facts that came in. And that was Wendy's problem. Her problem was that she had too many bad facts. But as you'll see here in a second, I thought she started off pretty well. Let's watch.
In the early, in the early morning hours of March 4th, 2022, the house was quiet. Kouri Richins fell asleep in her young son's room, like many parents do. At some point in the night, she gets up and walks back down the hallway to her bedroom. She slips back into bed beside her husband. She settles in next to him. She reaches over, and he feels cold. Eric Richins, the father of her children, the man that she has built a life with. Something feels wrong. She pulls the blanket up around him, but something still isn't right. He feels heavy. She turns on the light. And when she looks at her husband, really looks at him, she realizes something is terribly wrong. And in that instant, in that bedroom, in the quiet early of the morning, Kouri Richins' world collapsed. Reasonable doubt. It's not just a slogan. It's not just a suggestion. It's a constitutional shield that protects the innocent and prevents the state from punishing without truth. And it is the state that has that high burden, the highest burden under the law, to prove each and every single element of each and every charged offense beyond a reasonable doubt. The state stood up on day one and they told you they were going to prove that Kouri Richins had the means, the motive, and the opportunity to kill Eric Richins. And we're going to talk about each of these, but first, I want to talk a little more about reasonable doubt. I've told juries for a long time that one way to understand reasonable doubt is, are there other reasonable explanations as to what happened? As you look at the evidence, if there are other reasonable explanations, this is reasonable doubt. And you have to find Kouri not guilty. I put to you that every fact that the state has put forth to say that Ms. Richins is guilty has another reasonable explanation. Let's go back to March 3rd, 2022. From everything we've heard during this trial, Kouri and Eric were happy that night. They were celebrating. Kouri was just about to close on the Midway mansion. Rightly or wrongly, she believed.
And again, the optics of it too, right? You're forged life insurance policies and you're cheating and there's evidence you want to run away with another person. All that happens and your spouse winds up dead. It's going to be tough for you. It's going to be tough for you to beat that one.
That this was going to be the deal that put her over the top. The deal that had made everything she'd done with her business, the good, the bad, and the ugly, all worth it. The night of March 3rd, they have a celebratory drink, they go to bed, and then Kouri hears one of her sons cry out. And like parents all over the world do, she goes in to lie down on the floor of her son's room. An alibi or the truth? She wasn't inconsistent when she told this story. She told everyone, I was lying in Ash's room. I was lying down with him. What does reason tell you? What does experience tell you? When she wakes up, she goes back to her room. Eric appears to be asleep. We don't know for sure what happens over the next 15 minutes or so. The state asks you to leap to conclusions about what she was doing during that time. Yet they have not shown you any evidence of this. They just tell you to believe it. But what does reason tell you? She gets up. She goes to the bathroom. She picks up her phone. We all pick up our phone all the time. Been away from it for an hour or two. She goes to the bathroom. Maybe she walks to the kitchen. Maybe she gets a drink of water. Maybe she lets out the dog. And then she goes back to her bedroom, phone probably in hand.
And so in this video here, this is the defense lawyer closing arguments. And the guy, Tony, is going to say what he thinks she could have done better.
Into the bed, next to her husband, again, realizes he's cold, pulls up the blanket, realizes something's wrong and turns on the light. It probably takes a moment or two for her brain to register what she's seen.
And again, Kouri's mom had a friend or someone that died in a similar way. Maybe worth looking into, perhaps.
And then she makes that call that nobody ever wants to make. She calls 911. A big part of this state's case is that Ms. Richins is not grieving properly. You heard this from a couple of different witnesses, 2 or 3. What does that mean? I was unexpectedly widowed when I was not much older than Kouri, and I had 2 roommates. How do you judge someone in that moment?
Well, she had been trending into gaslighting up to that point with a couple of canards, but then she gets to, you're judging the way that she's grieving. That is not what that was done. What was done was they judged the way that she acted in terms of
Judging the actions, not the grief. Big difference, right?
all of the crying with no tears. All that crying, not a sniff among them. And because she didn't display true emotion and she was eye blocking, again, that is, I think, where you kind of lose the jury when you say, well, she was just really upset, when nobody, we saw this, but we never saw any liquid, any moisture in there. Now, I admit the body cameras aren't the greatest in the world, but if you get caught stretching the truth, and I think that's what she's doing here, that's going to affect how the jury sees the case.
They said there were deleted texts off Kouri's phone, and that it looks like that probably was true. Why would you delete texts off your phone? Maybe because you were having an affair over the last 2 years? You might want to delete that off your phone before your whole husband's family finds out about it. Maybe because she was buying oxycodone. I mean, she asked Carmen for pain pills. Doesn't mean she killed her husband.
One thing you should try really hard not to do when you are trying to get your client exculpated from a murder charge is not make the state's case for them. She just admitted that Kouri bought drugs from Carmen. The drug she thought she bought was oxycodone, or so she says. And as a result of that, she says, that doesn't mean she killed her husband. Right now, the jury is suffering a logical disconnect. You're admitting something that, for the most part, you've denied, and you're saying...
So they've denied the fact that she even did that, and now she's admitting to it in the closing arguments, and that's a big part of the prosecution's case. So I agree with him here. This is not what you want to do if you're the defense team here.
It doesn't prove you killed your husband when, in fact, you did. And you gave it to him, and that's what killed him. And it's very much like the judge said the other day. It doesn't matter whether she thought she was overdosing him on hydrocodone or whether she thought she was overdosing him on fentanyl. It still killed him. I thought this was one of the bigger mistakes in her closing argument.
The phone searches. So the evidence showed that Kouri found out on April 13th that Eric died of a fentanyl overdose. And that's the day they took her phone and she gets a new phone. These searches are all done on that new phone. Searches of how much fentanyl does it take to kill someone, or how much fentanyl is a lethal overdose? I don't remember exactly. Yeah, because she just found out her husband died of a lethal overdose of fentanyl. You might want to know what that means. And she texted other things. They said, oh, she texted about women's prisons. Of course she's worried. An innocent person would be worried. Anyone would be worried if they just found out that they are a suspect in a homicide investigation. She would have been scared to death. She was looking for information based on what she found out after Eric died.
Now, I have to give her some credit here, too, because she's pointing out that these searches occurred after she was suspected of having killed her husband. And so, in some respect, that does make sense. But the fact that you would want to look at that in that situation, knowing that they've already seized your cell phone. This is your second cell phone that you're working on here. What makes you think they're not going to seize that? It's illogical from her point of view, but it's even more illogical from the lawyer saying, well, she just wanted to know because she was scared. Well, She had a right to be scared. She'd killed her husband.
And something else, they say it would have cost way more money than she had to rehab the mansion to live in it with Josh, which again, Josh said was fantasy. That wasn't going to happen. But if you don't believe him, look at text. Look at State's Exhibit 2-17D on page 33. This is where she and Eric are going back and forth on how much it would cost to rehab the mansion. And he says, we can't afford that. We don't even have time for that. What does she tell him? And you can look at it. I don't have it word for word. She tells them, no, we're not doing that. I just need money. I just need to give the numbers, to the investors.
And then the jury is probably thinking at this point, now, wait a minute, Wendy, what about that text where she said, let's live in the mansion and let's have some kids, raise a little farm, live the life of Riley, so to speak. You can't have it both ways. Either you were planning and dreaming of it too, or it can't just be him. He didn't send that text. She sent that text. He didn't say anything about having kids and raising them. And so, again, it's that stretching of the truth, that continual stretching of the truth.
Yeah, this guy breaks it down really well. I like how he's breaking this down, and he's making a lot of good points here.
Weighs on and annoys jurors.
The state wants you to find that the conversation Kouri had with Josh about his time in Iraq is somehow evidence or proof of murder. But Josh told you she was grieving, that conversation was about life and death and Eric and bow hunting and the supernatural, that it really didn't even seem that unusual at the time. He only thought it seemed unusual when the private investigator told him Kouri killed Eric. It's not evidence of a homicide. It isn't proof of anything. Yes, they were having an affair. Eric was also having an affair, possibly more than one.
Again, she keeps mixing the good with the bad. The first part of that was pretty good, but then she gets to Eric was having an affair, possibly more than one, and I heard no evidence that Eric was having an affair other than those ridiculous Brokeback Mountain texts, which you can't really call that evidence of an affair.
Yeah, that was weak evidence, that Brokeback Mountain thing. But please remember to like the video for Shadow of the Night Owl. Likes are free, and subscribe to the channel if you're not already.
And that continuing to beat on that drum is, I think, one of the major reasons why these people wound up losing this trial. And now I'm going to put the rest of this in context with this little bit that she said before the end of closing.
Instead, we ask, talk to each other about where you see reasonable doubt. Also, if Kathy or Alex or myself did something to offend you during this trial, please hold that against us and not against Kouri.
Two big mistakes right at the end. First, telling the jury what to do when they get in the jury room by dictating the procedure. That's up to the foreperson. And when you step across that line, it's like you want to be in the jury room with them. And I thought that was not a smart play on her part. And I don't have a problem with the part about talk about reasonable doubt. They should have done that anyway. But the other part I do have a big problem with, because it says that you are directing them how to go about making their deliberation. And then my
goodness, Shadow the Night Owl has been given a fatal dose of fentanyl, and he needs to get a shot of Narcan. Likes will help him buy some Narcan.
Final part, the apology. You can't go into court and treat witnesses like doormats. You can't beat up and abuse the sister of the decedent. You can't continually throw dirt on the coffin of Eric Richins. You can't be disrespectful to the judge. You can't be disrespectful to the opposing counsel, who has been nothing but respectful. And then offer a weak, lame apology at the end, saying, hold that against us, not against Kouri. Unfortunately, you are representing her, and you are the person speaking for her since she's not speaking. And so when you ask them to hold it against you, you're really asking them to hold it against Kouri. And so I thought that this closing argument had the potential to move the needle a little bit, but it clearly did not move the needle. Now, I know a lot of you are thinking, well, yeah, you know the end of the story now. That's true, I do. But I would have said this before. I watched that in real time, and I clipped out these sections of the closing argument because I thought they were over the top, or because I thought she did a good job on them. And so I'm not saying anything I wouldn't have said before the verdict came in. And of course, nobody had time to get anything out in between the time that the jury retired and the jury came back with a verdict. And we'll talk about that in the postscript. For now, the next video deals with the rebuttal closing. Thanks for watching. I appreciate you being here today, and especially if you have subscribed. That means a lot to me. If you have the opportunity today, try to do just one kind thing.
So do you want to go to the Emily Jane or watch what this guy says about what the defense should have done? I want to hear what he says the defense should have done.
This is a postscript video, and it looks at the ultimate result of a trial, and it looks at why the jury may have decided the way they did and what to make of it. It's a complete opinion, all my opinion, and that doesn't make it right. It just makes it my opinion. So take it for what it's worth. Let's get started. In the past, when I have done these postscripts, I've included clips from the trial, different days of the trial, and different moments that I thought were important. But the Richins trial was so disturbing on so many different levels, I didn't think I could do it justice by selecting clips from 3 or 4 days. And if you do more than that, it winds up being a 90-minute video, and nobody wants to sit through that. So here's what I'm going to do. You guys have to tell me in the comments whether you like it, whether you don't like it, and that would be very helpful to me, because I want to do something that's valuable for you and not something that's just valuable for me. So here's what we're going to discuss. We're going to discuss the defense's approach to this.
Now, one thing I'd heard the defense could have said was there were friends of Eric that didn't know he did certain drugs or didn't know he did things, right? And it came out that he did. So that's something that maybe you want to expand on a little bit, perhaps as the defense. Well, just because the family doesn't know doesn't mean it's not happening, which is also true.
Case, we're going to briefly discuss how the prosecutor handled the case and what he did that was so good. We're going to discuss some of the judge's rulings, and we're going to discuss the possibilities of an appeal and the chances therein. That doesn't sound like a lot, but I'm afraid that it probably will be a lot. So to start out with, the thing I think that disturbs me the most about this case is that it was defensible. Now, I would have given the state a 60-40 edge going into this because they had all the evidence and they had some good investigators. They got lots of good information, but they also screwed this up from the get-go in that they did not do a thorough investigation of the death at the time the death occurred. And so the fact that they didn't find any fentanyl in the house, for example, was something that should have been talked about a lot more than it was. Now, in my opinion, the reason they didn't find fentanyl in the house is because as soon as it was possible to do so, I believe Kouri went and grabbed whatever it was, that bottle or the package, whatever contained the fentanyl, and she took it out and threw it in a lake somewhere or dropped it in the sewer. Whatever it is that she did, she destroyed it. And that's why they didn't find any fentanyl, because she had time. You know, she was supposedly the grieving widow, but realistically, she was just a scheming murderer, and they hadn't figured that out yet. Now, you know, nobody has perfect foresight, so that would have been pretty hard to do on the evidence that they had at the time. Except I would have trusted my impressions and my beliefs based on how she behaved in front of that body camera, and I might have dug a little bit deeper, but that's just me. So the reason I say it was defensible is there were plenty of things that they could have talked about to establish reasonable doubt, that being only one of them. But the place where they really had a chance to get an acquittal was in the attempted murder. And they blew it by not putting on a defense case. If they had put on a defense case, you call an epidemiologist and you say, how many people develop food poisoning from eating sandwiches? And you have them put up the models and you show the large number of people in the country every year who develop food poisoning. And then you ask the epidemiologist what symptoms are associated with that and what symptoms are tracked. And then you have them explain that. So according to the United States Center for Disease Control, about 48 million cases of food poisoning, foodborne illness, occur each year in the United States, roughly 1 in 6 Americans. Now,
1 in 6, 48 million of food poisoning. That's a lot.
Typical symptoms tracked in surveillance include nausea, vomiting, diarrhea, abdominal cramps, fever, and sometimes dehydration. Now, interestingly enough, there are 128,000 hospitalizations per year and 3,000 deaths per year from foodborne illness. So there was a way to defend that particular claim. So why didn't they defend that? Well, I have a theory. It's only a theory, and I have pretty much no evidence to back it up, but it really is the only thing that seems logical to me. I think from the outset, they knew that Kouri was guilty. I don't think they tried as hard as they could have because they knew she was guilty. And the reason they knew she was guilty was the walk the dog letter. And I think that...
Well, that puts the defense team in a conundrum, right? What are you supposed to do if you think the person's guilty? Like, if you're the defense, do you do the best job you can despite that? Do you recluse yourself? What do you do? I mean, if you're a defense attorney out there, what do you do when you know your client's guilty? It always reminds me of a billboard I saw once. There was this lawyer and it said, just because you did it doesn't mean you're guilty. And I said, you know what? That's a good advertisement.
Took all the wind out of their sails. They didn't have a way to deal with that. And unfortunately, in a criminal trial, well, or fortunately for the system of justice, but unfortunately for them, creativity is not rewarded. You can't go to a scriptwriter in Hollywood and say, I've got this situation, write me a script to get out of it. Now, maybe you could have done that on ChatGPT. That would have been a really good thing to do. In fact, here's what ChatGPT came up with in this particular case. Reframe the letter as panic drafting, not script writing.
This is good. But remember, please like the video. Likes will help buy Shadow the Night Owl the Narcan he needs. Someone out there gave him a lethal dose of fentanyl, and he needs some Narcan to revive himself, sort of like the Pulp Fiction scene with Mia Wallace. So likes help contribute to Shadow the Night Owl's Narcan. And also, subscriptions to the channel also help contribute to his Narcan that he desperately needs. He's on life support right now. His lips are blue.
The prosecutor's narrative, she was crafting a lie and recruiting a witness. The defense needed a competing narrative. She was panicking and brainstorming explanations with family. A possible theme: people under accusation write down possibilities. That isn't evidence of guilt, it's evidence of fear. The defense could argue the letter was not instructions, but speculation. Think of it as equivalent to someone writing in a notebook, what if this happened? Could Eric have gotten fentanyl somewhere else? Maybe Ronnie knows something. The key idea, drafting thoughts, is not the same as planning perjury. Trial lawyers sometimes call this thinking on paper. And then if you really wanted to go after it, you could attack the prosecutor's translation because, unfortunately, the translation came in the rebuttal phase, but they should have planned for this. The rebuttal was powerful because he rewrote the letter, and defense counsel could have attacked the method directly by saying, look, when he gets up to talk about the walk the dog letter, he's going to rewrite that letter. Ladies and gentlemen, the prosecutor didn't read the letter, he rewrote it. And once you rewrite someone's words, you can make them say anything. That approach would emphasize the prosecution inserted meaning, that the translation was argument disguised as evidence, and jurors must rely on actual words, not the prosecutor's interpretation of somebody else's words.
Sounds like this would have been a better defense. ChatGPT would have done a better job defending Kouri.
And then they could have leaned hard into the grief and chaos narrative. At the time the letter was written, the defense could emphasize her husband had just died. Police were investigating. Her life was collapsing. She had financial problems. It was chaos and grief, and all of that caused her to write something down that maybe wasn't the smartest thing in the world, but they're messy thoughts. Grieving people don't write polished legal documents. That would aim to make the letter look emotionally chaotic, not calculated, and argue that the letter shows that she expected an investigation. But I really don't think they tried. I think what they decided to do was go after each witness and cross-examine them in the most pathetic way. And by that, I mean, instead of going after them assertively and using leading questions, they asked open-ended questions and they whined. I don't really know any other word to use than to say that they whined. For example, with Carmen Lauber, they could have said, you knew what the prosecutors and the detectives wanted. Yeah, I knew. And you knew you had to give them what they wanted or you weren't going to get your deal. Well, I don't know. It's a yes or no question. You knew that or you didn't know that. And if she fights you on that, then you say, what would have happened if you had said, for example, Kouri's innocent? What would have happened? You would not have gotten your deal, would you? So there are ways to deal with a hostile witness with a criminal record that would probably embarrass their mothers. But the long and short of it is, when you're serving a client, you have to do your absolute very best. And again, I think they were so demoralized by the walk the dog letter that they just kind of phoned it in. That's my opinion.
And if that's true, that's pretty unprofessional, though, of the defense team. But again, because it's like, if that's what you're going to be as a defense lawyer, I mean, you've picked the wrong job, right? Because if that's going to be your issue, that you're not going to be able to defend someone that's guilty, then you shouldn't be a defense lawyer. That would be my thoughts.
I am not accusing them of ineffective assistance.
Or maybe you could say, well, you know what? Maybe they're like prosecution's aides in that way. We're like, you know what? If we think someone's guilty, we're going to help protect the streets. Maybe that's their mindset. I don't know. But what do you think? What do you think their mindset is of doing it? If they really didn't put their all into it because they think she's guilty? Is it just because they're trying to help out the world? They don't want to have a guilty conscience? Or what do you think it is?
I know there will be people who ask, does she have a case for ineffective assistance? No. Nobody fell asleep at counsel table. Nobody admitted anything particularly damaging, although Wendy Lewis's admission on closing that she had gotten the hydrocodone tablets, that I thought that was pretty silly. But again, there's no ineffective assistance of counsel here. They were completely effective. They just didn't get the job done because the job couldn't be done because they can't lie and they can't ask a witness to lie. And so in that regard, I salute their ethics for not suborning perjury, not letting anybody get up there and lie. I think that's the reason, the whole reason why Kouri's mother didn't testify and why they wouldn't call her, because I do believe that Kouri's mother would have supported her story. So there's that. Now,
So, did you hear that? That's actually pretty big. So, he thinks that they didn't call Kouri's mother to the stand because she would corroborate Kouri's story and they didn't want perjury committed. Interesting. Do you think that's accurate? Do you think that's what it was? They didn't want her to commit perjury for her daughter? Press 1 if yes and 2 if no. So the question is again, do you think they purposefully didn't call her mother to the stand because they didn't want her to lie on her daughter's behalf? And this is the defense team, mind you. So 1 yes, 2 no.
looking at the prosecutorial tactics, they were golden all the way through. They did a great job of pinning the tail on that donkey. They put the fentanyl in the bottle. They put the bottle in her hand. She was the last person to see Eric Richins alive. She admitted on the body cam that she fixed the drinks, that the medical examiner said there was only alcohol and fentanyl in his gastric contents. And that's game, set, and match in this case. So again, the prosecutorial team in this, and looked like mostly Bloodworth, although the other prosecutor did take a few witnesses in there, did a phenomenal job of putting the evidence on in the case. Now, let's talk about appellate issues. The best appeal is no appeal, because you don't have to appeal if you win. And I once made a suggestion to one of my partners that for purposes of appeal, he might want to do a certain thing. And he said, no. I said, why not? Don't you want to preserve the record? I play to win. And the best appeal is no appeal. And in that case, he was absolutely right. When you have a weaker case, sometimes you have to make some of those allowances. And they did do a pretty good job of preserving the record, but here is the problem. The problem is that almost everything that they complained about was evidentiary issues. Now, it is black letter law in almost every jurisdiction that a judge has discretion on which evidence to admit and which evidence to keep out. On the Rule 403 balancing test, more prejudicial than probative, right? That's the formula. It has to be more prejudicial to the defendant than it is probative of her guilt in order for it to be excluded. That's a balancing test, and that balancing test is done by the trial judge. In some cases, the judge might make a decision that would be different than the appellate court would make. But here's the thing, the appellate court can't reach over them and fix that error in most cases unless it's just a very clear black letter violation of evidence law. That's because of the issue of discretion. The rule is that generally speaking, the rule is that if reasonable minds could disagree about the propriety of the judge's action, then there is no abuse of discretion.
That's a good way to put it. We actually have a good like to view ratio here, surprisingly. But remember to like the video. Likes are going to help pay for Shadow the Night Owl's Narcan. He got a almost lethal dose of fentanyl this evening. And also remember to subscribe to the channel if you haven't already.
And evidentiary issues are resolved under the abuse of discretion standard. So in my view, there may very well be a ton of appellate issues in there, but there are none that are really viable. And I would point out something else. Most of the close calls on the evidentiary issues went to the defense. And in the jury instructions, I did not believe that a snitch instruction was appropriate. And yet, they got a snitch instruction. And the judge was doing that to appeal-proof the case. And in fact, he pretty much leaned on Bloodworth to bring Carmen Lauber back in order to, again, appeal-proof the case. So when I look at this case, what I see is pretty much a per curiam affirmance when it goes to the Utah Court of Appeals, and I don't look for the Supreme Court of Utah to come in and turn that around. So that's what I have for you today. Hopefully you find that helpful. I'm sorry it's just me talking on the camera today, but I think for the most part, like I said, this trial was so long and there were so many witnesses that you could turn a postscript into a 2-day event if you wanted to. And I don't wish to do that to any of you guys. I love you guys. So again.
So this is, his channel is called JD, A Lawyer Explains. I like how he breaks down this stuff. So I think this guy will be strictly for court cases. So that's probably why he hasn't talked about Nancy Guthrie, if I had to guess. Has he ever? Somehow I doubt it. But you'll probably hear him talk about Nick Reiner when that case comes up. Maybe Michael McKee when that case comes up too, by the way. Well, I guess we'll play some of this. This is from the Emily Show.
May I ask you a yes or no question? Has the jury reached a unanimous verdict?
Yes, we have. It's day 15 of Utah versus Kouri Richins. And this case was slated to go a lot longer. And all of a sudden it just came to a screeching halt. And I know that for me, it's a little difficult sometimes to just reset. But here we are resetting today for closing argument. It's, one could say, an epic day. Closings are one of my favorite things. What do we expect today? There is unlimited time for closing argument. We'll see if that's a blessing or a curse. The defense said that Attorney Lewis was doing closing, but then Attorney Nestor kept saying, so I can argue this and I can argue that. It was like she was prodding the judge to figure out which theory of the state she was going to argue, and the state just sit there and was just silent because that's the only thing you can do. She's like, but if this and what about that? And it's like, girl, the judge isn't writing your closing argument for you. And what I expect that we will see today is pre-instruction, which means the judge will give the jurors the instructions.
Emily's hair colors remind me of Corella DeVille. They got the black and white going on. I like it on her, though.
Then the state, then the defense, then the state, if they get to it. Then I expect that we will, well, we'll see if that gets us to the end of the day and there's any time left for deliberations with unlimited time to close. Who knows how long closings may take? I think anything over 3 hours from either side gets to be on to a bit much. But there's a lot of nuance to this case. And remember, there is a murder, an attempted murder, 2 counts of insurance fraud, and 1 count of forgery. I expect we'll see the defense attorneys use their jury instructions in their closing arguments quite a lot. I expect we'll see the defense try to cash in on some of the promises they made in opening. Let's go to court, shall we?
Kouri Richins feels aggrieved and is thus an intensely ambitious person. She feels aggrieved because growing up, her father was an alcoholic who traded parenting for prison.
Holy
and her
shit.
mother, a gambler who traded parenting for a casino. Kouri Richins thus worked for her aunt, cleaning the homes of rich people in Park City. She was not beneath those homeowners, but she felt that she was. This fueled in her an intense desire to appear privileged, affluent, and successful. First with Eric's money and then other people's money.
OPP.
Kouri Richins carefully curated the facade.
Close enough.
Of a privileged, affluent, successful business owner. Behind the facade, however, Kouri Richins was incompetent. She took tremendous risks.
Oh boy.
She borrowed money by any means necessary at exorbitant rates.
She's going to hate that.
She gambled other people's money and lost. Her business was imploding. Kouri Richins is an intensely ambitious person. She is a risk taker. There was a way forward. Eric had to die. As Judge Mrazek just instructed, there are 5 counts. And each count has a series of elements. The state has to prove each count and each element of each count beyond a reasonable doubt. That is our burden. In this closing, we will go count by count, and then within each count, element by element.
I like how they broke these down with the 2 insurance fraud, the scheme of the insurance fraud, the claim of the insurance fraud. I think it's incredibly helpful
to show to you how the state has met its burden of proving.
Overall, this guy just seems more organized and clear than the defense from what I've seen so far. Bloodworth.
Aggravated murder, attempted aggravated murder, 2 counts of fraud and forgery. The evidence will prove that Kouri Richins was the person who committed the aggravated murder. The evidence will prove that she intentionally or knowingly caused the death of Eric Richins, here by means of administering to him the illicit street drugs that she purchased from Carmen Lauber. She intended to kill him with the illicit street drugs. It doesn't matter what illicit street drugs. We'll get into it more. It doesn't matter if it was the propofol, if it was the fentanyl that actually killed him, if it was oxy or some other illicit street drugs. She bought illicit street drugs to kill Eric Richins. Here we have an aggravated murder charge, and the state will prove 2 separate and distinct aggravators. The first is for pecuniary gain. This is a why aggravator. Why did Kouri Richins kill Eric? For money.
So establishing the motive first, and then the other points are going to be in support of the motive.
The second aggravator is a how aggravator.
They only need
how
one
did
of
she
these.
do it?
But they can
Here,
find both.
By the administration of any substance. Here it happens to be fentanyl, but it could be any substance administered in a lethal amount.
It doesn't have
Either
to be
one
an
of
illegal
those
substance.
aggravators are what transforms this case from a murder case
An aggravated.
to an aggravated murder case. Kouri Richins asked 2 people, Hayden Jeffs and Carmen Lauber, for the Michael Jackson drug. Kouri Richins was a suburban mother real estate agent. She does not know a lot about the illicit street drug world, but she knows Michael Jackson died from taking drugs. She doesn't know how to order a street drug, but she knows she wants the Michael Jackson stuff. She knows she wants it because
She
it
wants
is
the
lethal
stuff.
it is fatal, it kills. And she wanted lethal, fatal death. We also know that Kouri Richins
There it is.
intended to kill Eric Richins because the toxicology contained quetiapine.
Last one. What is quetiapine? Quetiapine?
Quetiapine is an antipsychotic medication. It's called Seroquel.
Okay.
It's a prescription mental health medication that's prescribed for different things.
I got you.
Uh-huh.
The quetiapine in the toxicology
Why are you faking?
for Eric Richins shows that Kouri Richins was involved because she was prescribed quetiapine. Now, this conversation that she recorded with Dr. Christensen is also very insightful. She pretends to not know what quetiapine is. It's her
Lies, right? Another lie.
prescription.
It's a drug she takes
Of course she knows what it is. She pretends to not know what it is to cover up her involvement in putting the quetiapine inside Eric's body. She covers up her conduct in murdering Eric Richins in several ways throughout, beginning the night she murdered him, all the way through the walk the dog letter.
Docket 214.
In the orange notebook, she writes, she jumped out of bed, ran, turned on the lights, grabbed her phone, and called 911.
That's not quite accurate.
The evidence proves that is not true.
Here's
The
that evidence.
proves that when she returned to their bedroom, Kouri Richins says she was in Ashton's room. There's no evidence of that. But she returned from somewhere to their bedroom, unlocked her phone, put it on speaker. There's no call detail records showing a call at that time. But she may have called on Wi-Fi, somebody. That would not appear in the call detail records. It would appear on her phone.
Kouri does not like this argument at all. Damn.
But she may have called on Wi-Fi, somebody. That would not appear in the call detail records. It would appear on her phone if her phone had not been deleted.
Objection, Your Honor. These are facts that are
Overruled.
not.
Please have a seat.
Sit back down, Miss Lewis. But what if it's not in evidence? He didn't say she did. He said she may have. Why was the speaker turned on her phone? Is it a reasonable argument from the evidence that the reason the speaker would be on is because you're on a FaceTime call? That is a reasonable inference from the evidence. But he told her to sit back down.
She then unlocked her phone again at 3:08, 3:10, 3:15.
All right, one objection.
3:19, 3:19. And then 15 minutes later,
The slide
she called
shows
911.
the phone activity.
That is not immediately called 911. We're going to listen to the first part, actually most of the 911 call again.
The 911 call that Kouri called.
I ask that as you listen to it, you'll hear the first minute. The first minute is not the sound of a wife becoming a widow.
Oh, shit.
To echo her friend Chelsea Barney, the first minute is the sound of a wife becoming a black widow.
Oh, damn!
We're going to run.
It was like an episode of Seinfeld when George finds out that Susan was killed by the stamp poison. And then Susan's parents say, I could best describe George's attitude as controlled jubilation.
A clock from the time that the dispatcher asks her if she can start CPR to the time
No.
she purportedly starts it.
Oh, boy.
It's 6 minutes.
Oh, shit.
Contrast that 911 call with her self-serving text message to her best friend, Chelsea Barney. I tried so fucking hard to save him, his lifeless body on my bedroom floor. I pumped so damn hard, so hard, screaming at him to come back to life, that I needed him.
Oh, boy.
None of that happened.
Yeah, you would have heard it.
She's covering up her involvement in murdering Eric Richins.
Yeah, where's the screaming?
Sheriff's deputies gave
Putting on a performance. An Oscars performance is what it sounds like she was doing.
Kouri
This is the
Richins
death
early
form.
morning of March 4th to write out what happened. It says, describe in detail what you saw, know, or heard of the incident. Where does she start? Eric and I put the kids to bed around 9 p.m. We had a drink. In Kouri Richins' mind, that's when the incident started. It was the drink, and she knew it because she put the fentanyl in the drink.
That's a solid connection.
She didn't start with, I walked into the bedroom at 3 a.m.
Damn.
My husband was not breathing and cold.
Damn.
Describe the incident. The incident for her begins around 9:15 when she has the drink, because she knows that is in fact when the incident began. Kouri Richins would borrow money
rough.
by any means necessary.
Yep.
6 times she submitted inaccurate bank statements to lenders to get money.
6 times inaccurate bank statements to get loans.
Oh, that's a lot of exhibits.
Those bank statements reflected her business account and balances in C&E's business account.
Oh, the spliced accounts.
This evidence proves the level of financial desperation that Kouri Richins was in late 2021 and early 2022. Kouri Richins needed cash immediately when she murdered Eric. Eric's long-term earning potential, immaterial. She wanted to close on the Midway mansion. She had no money.
Yes, Shadow the Night Owl needs his Narcan. Likes help him get Narcan because an associate of Kouri Richins also slipped him a lethal dose of fentanyl, and no one was there to pound on his chest. Narcan by means of likes is the only thing that'll help him.
To refurbish it, to flip it right away, to run it as an event center. But she was going to close on it. She needed money now. Doesn't matter if Eric's going to earn a ton of money down the road. That does not help her now with the Midway mansion. It does not help her now with servicing her existing debt. She needs money now because she's closing on the Midway mansion on March the 4th. She didn't want to close until she knew Eric Richins was dead, because she knew she would have his money. She knew she could do something with the mansion. And that's why when everybody else signed on the 4th, or in advance of the 4th, she signed on the 5th. It's unconscionable that she closed in spite of his death.
Defense has their mics on.
It's unconscionable that she closed because of his death. Now for the aggravator of administration of any substance.
We're only on to the second aggravator.
Any substance in a lethal amount. The substance here happened to have been fentanyl. Could have been any part of the illicit street drug that she bought. Happened to be fentanyl that she administered in a Moscow Mule and a shot or a shot. But we know that's how she administered it because
she said it.
Belly.
Right. It was in his belly and she said it.
We know it was a lethal amount.
In his belly, and she said it.
They really did a good job on the pauses.
Fentanyl killed him. That's the substance. Lethal amount can be as small as 3 nanograms per milliliter. And in this case, he had 15. 5 times what can be a lethal amount. That, by the way, is not an accident. That amount of fentanyl shows that Kouri Richins wanted Eric not only dead, but good and dead.
Oh, shit. Oh, I wonder if this will spill over into talking about the attempted murder, right? She didn't just want him dead. She wanted him good and dead. She wanted him actually dead because of February 14th.
Now, count 2.
Yep. That makes so much sense.
In each instance, she purchased drugs from Carmen Lauber a few days out. In each instance, she spoke with the IRS a few days out. taxes were on her mind.
Interesting.
Eric would find out if the IRS was after them. In each case, she had an immediate financial stressor.
That's also the reasoning when they give someone a lethal injection, they give you many times what would be a lethal dose because they want to make sure you're dead and not half dead.
Discuss closing on the Midway mansion. If you look at Brooke Carrington's materials, she had a note due on Chelsea Barney's house.
That's right.
Before February the 14th. She had an immediate financial stressor in each instance. In each instance, she administered the substance in a way that Eric would ingest it.
Great slides.
On Valentine's Day, it was a sandwich. When she murdered him, it was a drink. Notice that she learned from her mistake.
That's what we said.
One can season a sandwich with fentanyl. Eric can eat it,
Not
tell
finish
something's
it.
wrong, set the fentanyl-laced sandwich aside.
Not in a shot. Not in a drink.
You throw a lemon drop shot back. By the time Eric would notice, the shot was in. It was in his body. Moscow Mule, just to be good and sure.
Wow.
In each case, she leaves Eric alone. She distances herself from the dirty deed.
Done
She
dirt
leaves
cheap.
the bedroom when she murders him.
Look at her, the AC/DC quotes. That's why Kat likes her.
She leaves the county when she attempts to murder him.
Song lyric, not commentary. Sorry, chat.
That's part of her alibi. Not only can she not be present,
Yeah, she got an old school music taste that confused her chat.
she has to be distant. So that when she calls 911, she says, I wasn't even there. I was in Utah County.
Great parallels.
And in each case, she has a delayed response, right? It's the delayed response in calling 911 when she murders him. And it's her delayed response in returning home when she failed to murder him. Count 3, the scheme charge relates to the $100,000 true stage policy. We're going to put it up in a minute. The fraud claim charge relates to the $250,000 true stage policy. The forgery, which we will get to,
It's a signing.
is a forgery related to count 3, the scheme charge. The scheme is quite simple. Kouri Richins wanted to murder Eric Richins, thus took out an insurance policy on his life to get money for murdering Eric Richins. Then she murdered Eric Richins, and then she submitted a claim to get the money. That is the scheme. And we know it was Kouri Richins.
I'm still stunned they paid her, honestly.
Everything on this application for this $100,000 true stage insurance policy returns to Kouri Richins. After Kouri Richins took $250,000 out of Eric's home equity, he put all of his insurance that he knew about into the trust.
That part.
If Eric had filled this out, the beneficiary would have been the trust, not Kouri Richins. Then we'll get to the signature.
Look at that. Motive, premeditation. Ooh.
That's the fraud count 5
That
as well. It plays into this.
is
We'll talk to it during count 3.
That is a very good point with the beneficiary information.
And this is where it's not even for her about just leaving him and running off with the other guy. She wants this money too. And Eric is just in the way. And a way to also, if he's dead, get this money. Because narcissistic people, they see people as objects to be used. They lack empathy and they don't care. They are extremely selfish. And this is her way for more power, more control, etc.
He knew that everything was beneficiary to the trust. So why would he make this a beneficiary to her and undermine the trust that he set so much time and effort and money setting up?
Now for the insurance fraud claim count 4.
I like that he's walking through these counts. I think it's needed.
This is the True Stage $250,000 policy. This is the claimant's statement filled out. Kouri Richins, beneficiary.
I mean, I watched every minute of this trial with all of you, and I still forgot this document. I know we saw it.
Remember, Dr. Salerno said, all psychopaths are also narcissists, but not all narcissists are psychopaths.
I know we talked about it. Still forget.
Everything about this claim says Kouri Richins is submitting this claim.
That's her handwriting from everything that we've seen.
And then
the phone calls.
Like before, the fraud here, the falseness of it is she says she doesn't know where the fentanyl came from, when in fact she ordered illicit street drugs from Carmen Lauber. We've discussed most of the forgery when we discussed count 3. But there's this without the authority to do so element. It's not a forgery if Eric gave Kouri Richins permission. The state has to prove that Kouri Richins did not sign Eric's name with permission, with authority.
And this is the last count. I imagine they're just about done with the first part of their closing. Because why would he have given her permission?
All of the evidence in this case proves that Kouri Richins does not ask for permission, she takes. The evidence proves that Kouri Richins attempted to murder Eric Richins, and that she committed 2 counts of insurance fraud and forgery. The evidence does not support any other rational explanation.
I think he might be done with his part of the closing. I imagine they'll take a break.
The state, since its opening statement, has stressed the requirement to consider the evidence that has been admitted and not what the attorneys say. What the attorneys say, insinuate, speculate, is not evidence.
Oh boy.
He's right. But also, please remember to like the video. Likes are free. Slap that like button. Subscribe to the channel if you're not already. Come say hello to the flock of black sheep. We got people in here from all over the world. Netherlands, England, America, all sorts.
Please let me show you why the state has stressed this. In the defense's opening statement, counsel said that the evidence will show that Kouri Richins had a 1/2 interest in the Willow Court home. There is no evidence of that, and indeed contrary evidence. Defense counsel said that the evidence would show that Eric was always checking Kouri's phone.
Oh boy.
There's no evidence of that. Defense counsel said that the evidence will show Eric and Kouri Richins went to marriage counseling. There's no evidence of that. Defense counsel said that the evidence will show in the few weeks before Eric died, his closest friend thought that he and Kouri Richins were the happiest together that the friend had ever seen. There's no evidence of that. Defense counsel said that the night Eric died, he and Kouri Richins had their drinks and set their cups in the sink. There's no evidence of that. Defense counsel said that the evidence will show that the cups were sitting in the sink and the nanny put them in the dishwasher the next morning and they still had fluid in them. There's no evidence of that. Defense counsel said that Eric talked to a friend named Scott Wagner at 10 p.m. the night he died. There's no evidence of that, and indeed contrary evidence. Defense counsel said that the evidence would show Eric unlocked Kouri Richins' phone at 10:30 p.m. the night he died, and this is the last thing that he did.
Oh boy.
There's no evidence of that. Defense counsel said that the evidence would show investigators interviewed Kouri over and over and over again about what happened the night that Eric died.
It does show they interviewed her at least twice.
There's no evidence of that.
Over and over and over again, no, but at least twice.
Defense counsel said that the evidence would show that law enforcement secretly recorded Kouri Richins' phone conversations for over a year after Eric died.
Did they say that?
There's no evidence of that, and indeed contrary evidence. Defense counsel said that you will hear Kouri Richins telling her family that she purchased pain pills for Eric at his request.
It's in the Walk the
You
Dog
did not
letter.
hear that. Although she did write it in the Walk the Dog letter.
Fair.
4 months after she was arrested. In listening to defense counsel's closing argument, please only consider the evidence that has been admitted.
Damn, Bloodworth. Can the prosecution comment on what the defense showed and didn't show without burden shifting? Yes. They did not say that the defense had to show you this. They said defense said the evidence would show this. It did not. That the evidence would show this. It did not. That the evidence would show this. It did not. They're not saying the defense has to show you. The defense failed to prove. The defense said the evidence would show. The evidence did not show. Leonard, a quick thank you to.
It's good. Excuse me. It's a good breakdown. So this is her, the defense lawyer.
EDB. Just one more time. Gusto.com/EDB. Now let's get back to the case briefs.
In the early morning hours of March 4th, 2022, the house was quiet. Kouri Richins fell asleep in her young son's room, like many parents do. At some point in the night, she gets up and walks back down the hallway to her bedroom. She slips back into bed beside her husband. She settles in next to him. She reaches over, and he feels cold. Eric Richins, the father of her children, the man that she has built a life with. Something feels wrong. She pulls the blanket up around him, but something still isn't right. He feels heavy. She turns on the light. And when she looks at her husband, really looks at him, she realizes something is terribly wrong. And in that instant, in that bedroom, in the quiet early of the morning, Kouri Richins' world collapsed. I put to you that every fact that the state has put forth to say that Ms. Richins is guilty has another reasonable explanation. Let's go back to March 3rd, 2022. From everything we've heard during this trial, Kouri and Eric were happy that night. They were celebrating. Kouri was just about to close on the Midway mansion. Rightly or wrongly, she believed that this was going to be the deal that put her over the top. The deal that had made everything she'd done with her business, the good, the bad, and the ugly, all worth it. The night of March 3rd, they have a celebratory drink, they go to bed, and then Kouri hears one of her sons cry out. And like parents all over the world do, she goes in to lie down on the floor of her son's room.
Her lying on the floor is not evidence, but.
Or the truth.
Okay.
A big part of this state's case is that Ms. Richins is not grieving properly. You heard this from a couple of different witnesses, 2 or 3. What does that mean?
Sounds like Erica Kirk.
I was unexpectedly widowed when I was not much older than Kouri.
What? Ma'am, that is some tenuous ground and cross, Miss Lewis. That is a really fine needle to thread. That is a really fine needle to thread.
Is not grieving properly.
I backed
you
up.
Heard
That's
this from
not.
a couple of different witnesses, 2 or 3.
That's not.
What does that mean?
You're going to get real close to vouching.
I was not much older than Kouri, and I had 2 little.
Could you ever imagine if there's an Erica Kirk trial and this is the breakdown? Erica, Were you working with the IDF to have this done? Erica, did you associate with this person from Turning Point USA and have freaking Candace Owens be the prosecutor?
How do you judge someone in that moment? If I've learned one thing during this trial, I've learned I didn't grieve right. I didn't know that, but it's clear now that I didn't. They want you to look at a woman in the worst moment of her life and to judge her grief. There is no wrong way to grieve.
Oh, ma'am.
They're asking you to judge how she is acting at that moment and then use that moment of evidence of guilt. Oh, she didn't tell the boys when she should have. It was weird. She didn't go talk to them. They were in the playroom. Again, because she felt guilty or because she was dreading the most.
I think she's wasting her time in what she's even focusing on in this defense. You want to focus more on the places that you can emphasize deniability, right? That's what you want to focus on, I would think, if you're the defense. Emphasize that, not this character story of grieving wrong. This is not going to land well.
Difficult conversation. The conversation nobody, no mother ever wants to have with her young sons. Their father is dead.
I think that point's fair.
The father that everyone agrees was a wonderful father is gone, and she has to tell those little boys, you're never going to see him again. Believe me, that conversation may be the worst moment in a mother's life. How can a woman be judged on how she handles that moment? Let's talk about the investigation. The investigation in this matter was nothing but sloppy. It was driven by bias. Did you notice during the state's closing, they didn't really even talk about the investigation? Instead, they speculated. What was in people's heads? What were they thinking? Speculation, conjecture.
Better.
Not proof.
Kouri's words.
Instead of looking at the evidence to determine what happened, the state they determined what happened.
And Kouri's words, as she said, though.
And then they found the evidence to support it. This is confirmation bias. Confirmation bias is when you favor evidence that supports a belief and ignore evidence that contradicts it. That is how this entire case was investigated.
Ma'am, same initials.
Working backwards from a conclusion.
Wrong case.
I want to talk about the lead investigator, Jeff O'Driscoll. Here's what he testified that his investigation.
Your turn, O'Driscoll. Smoke.
He got assigned to the case sometime in March of 2023. He got a search warrant for some medical records. He thinks he got a search warrant for a couple of cell phones.
He was not great.
He interviewed Chelsea Barney, where they discovered that they were wrong about some text messages. Law enforcement was wrong with what they thought they were looking for. He interviewed someone named Jake Sorensen, who must not have had anything important to say because we never heard from him. Then he interviews Carmen Lauber because he was told to by the private investigator. That's it. That was the investigation.
What is Jake catching strays?
He didn't investigate any other leads. He didn't attempt to corroborate information, particularly in the letter that we saw that Kouri wrote to her mother, the walk the dog letter. Now, he told you he didn't need to corroborate that because he didn't get that letter till after Kouri was arrested. So, I guess the state was done. You wouldn't want to start looking for things that might show her innocent. You've arrested her. Interestingly, they were still executing search warrants. They were still
Emily didn't have much to say about that part.
Trying to find evidence for guilt, but they weren't looking at any evidence that might show innocence.
Pounding the table and arguing the Constitution kind of go.
It is absolutely possible that everything she said in that letter was true. In fact, at least 3 things in that letter.
This is a good argument. I just wish you would stop yelling at me because this is a good argument.
Were corroborated by the state's own witnesses. But they didn't investigate it. Again, ignore what might contradict your theory. Confirmation bias. Reasonable doubt. Sitting here in this courtroom after 4 years of investigation, there was an awful lot that O'Driscoll just could not tell you.
And so she's been in prison. I shouldn't say prison, county jail for 3 years.
Things he couldn't remember. He couldn't remember what people had told him in interviews. For example, he was asked, did you interview Eric's allergy doctor? Well, yes, but I can't remember what he said. Well, that might have been important because he testified the EpiPens in the house belonged to the children. Well, maybe because Eric had recently used his a couple of weeks earlier when he had an allergic reaction. He said, well, if I could have a few minutes, I could find out what was said. I could give you more information. We were in trial. He was on the stand 4 years after Eric had died. 3 years after he'd been appointed as lead investigator. And either he wasn't prepared to testify or he just didn't know.
I mean, it's fair. O'Driscoll was not great.
He is the lead in.
However, I will say the symmetry of this shot from whoever is operating the camera, producer snaps for this. You got O'Driscoll with the former attorney Sky Lazaro over his shoulder. And then you can see Eric Richins' sister and brother-in-law right behind Sky.
We know he had norfentanyl in his body. And this is
Skylar looks like she would have done better to me.
Because his body had started to metabolize the fentanyl. The state's toxicologist told you that the fentanyl could have been left over from a previous use. That was a possibility. Another reasonable possibility. The fentanyl was there from a previous use. That was the evidence. That is reasonable doubt. What else do we know from the ME and the toxicologist? Well, we know that the fentanyl was not
how I remember that testimony.
There was only fentanyl in the blood and not alcohol. The state's toxicologist leaned toward the fact that maybe Eric didn't even drink alcohol, that the alcohol in his stomach was post-mortem decomposition.
Yeah, she said it was possible.
But the other scenario that she said that was possible was that Eric took the fentanyl, then took the quetiapine, had a small amount of alcohol.
Also possible.
She testified that it would take 15 to 60 minutes for fentanyl to make its way into the blood. That alcohol takes 15 to 30 minutes to make its way into the blood. So if the alcohol and fentanyl were taken together, they both would have been there at the same time in the blood. But just the fact that one reasonable possibility is that the fentanyl was taken before the quetiapine and the alcohol gives you reasonable doubt that it was placed in a drink an hour earlier. Dr. Christensen testified the ME's office didn't know enough about Eric's history to determine if it was an accident. They also didn't have enough information to determine it was a homicide. The ME had at least a reasonable doubt as to the cause of death. And the ME isn't held to the high standard that the state is.
It's a good argument.
And there was no evidence that the autopsy could have been amended at a later date if additional information was received.
But it's not a criminal.
The ME testified, excuse me, the ME didn't tell you that they couldn't amend the autopsy. He just told you they didn't. Carmen Lauber, interestingly, they barely mentioned Carmen Lauber in their closing. The only witness who can put fentanyl into Kouri's hand. Let's talk about her testimony.
Oh boy.
Admittedly, a lot of it was painful to watch. And in some ways, she's sympathetic. But she is looking at multiple long prison sentences.
That's not what came out.
And her only way out, her only way was to testify at this trial. But what she could not do was put fentanyl in Kouri Richins' hands. She told you that she had no memory of what actually took place in 2022. During those interviews, she told detectives over and over again, my brain is fried. I've been using drugs since 6th grade. My memory is gone. So what she testified to you wasn't what she remembered. She admitted on the stand that what she testified to was what she had been shown, what she had been told. In the state's last question to Detective O'Driscoll, they brought up the TV show, The House of Cards, but who held all of the cards in this case? Jeff O'Driscoll told you. Carmen Lauber held all of the cards. Their entire house of cards is being held up by her.
Hmm.
And now at trial, 3 years later, she comes in here and says she bought oxycodone once and fentanyl 3 times.
Tell me
Well,
if
she
that
had her
lands
story
for
down.
you.
She told it very nicely on direct. But when pressed, she couldn't remember anything. Not from 2022, not from 2023. She couldn't remember on Friday what she testified to on Thursday. And I didn't ask her about her mental health or her learning disability to be mean. I asked her because it explains why she was so easily convinced by law enforcement as to what she needed to do and what she needed to say. She described her learning disability as low education. Well, you can decide what that means for yourself. But one possibility is she has an intellectual disability.
Ma'am!
And if that is the case, she is more vulnerable to suggestibility than most people.
Danger! 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 Danger, counsel! Danger! Nope! Nope!
There were a couple of little things she lied on the stand about.
Not sure why she's so upset about that. I think it's true.
Not super important, but I'm going to point them out because they were just untruths. When I asked her if she was on any medication for her anxiety or any other illnesses, she said no. But then later, when Mr. Bloodworth asked her, she said yes, she was on medications. They were in her car in her purse. She told you Nancy Peterson drove to buy the drugs because she didn't have a driver's license. When we showed her that photo was reversed and that she was driving, did you notice how smoothly that story changed? Oh, well, yeah, I drove one way, she drove the other. By the way, where's Nancy Peterson? There was someone who might have been able to confirm Carmen's story, but we didn't hear from her. What else did Carmen lie about? She said on that stand, and she told you, I never violated drug court after I got out, my get out of jail free card in May of 2023. But then when confronted, she had to admit, oh yeah, I did. That's right. She told you, well, I was holding a can of alcohol, but I didn't drink
At the concert, right.
When confronted, though, she had to admit that wasn't true. She said on the stand, and she told you that. Oh, I just held it. Oh, but you told your probation officer you drank it. Oh, yeah, I guess I drank it. But what's the most important thing she admitted to lying to? She lied to a judge. She lied to a judge
And
by writing a letter
that's why they
saying
wanted to bring Carmen back in.
that she had been 100% compliant with drug court. And why did she lie to that judge? She wanted to go to Vegas. And she told you on the stand, she admitted it. Yeah, I was untruthful with the judge.
And
to get
some
something that I
jurors
wanted.
might discount her for that. They might.
She was untruthful because she wanted to go to Vegas.
But the
There is
phones,
a
though.
lot more at stake here than going to Vegas. She is, again, being untruthful to get what she wants. And what she wants this time is to stay out of prison. And she will say whatever she needs to make that happen. Can you feel for Carmen Lauber? You can. Can you believe her beyond a reasonable doubt? You cannot.
But you...
And if you can't believe
Okay.
her beyond a reasonable doubt, you have to find Kouri Richins not guilty.
I don't think that follows.
I'm not going to stand here and say to you that Eric Richins was a drug addict. He wasn't a Carmen Lauber. He wasn't a Robert Crozier. I don't think the evidence shows that.
Ma'am?
But that doesn't mean he didn't use. That doesn't mean he didn't ask Kouri to get him pain pills. He probably did. So what do we know? We know Eric was in pain. He had Lyme disease, which can be very painful. He had back pain. He had knee pain. We know he'd been in Mexico not long before his death. Look at what he was doing.
So then why did he need Carmen to get him pills? I mean, why did he need Carmen to get him pills? This is the state's
texting.
exhibit she's showing
Pedro Sonora, back and forth,
with
back and
his
forth.
phone activity.
Did they interview him? Like we said, no. He texts his friend Scott Wagner. More, Pedro Sonora, from 8:30, between 8:30 and 8:36, he texts him 1, 2, 3, well, these are back and forth. But between them, there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 texts. Maybe he made other calls. The state said maybe Kouri was calling on the Wi-Fi. Maybe so was he. We don't know who else he talked to, but this is what we do know.
Well, ma'am, we had his phone though. So, I mean, they could see if his phone made other calls because they had his phone. It wasn't wiped. So there,
this is a good place to bring up, I think, that the state did stand up here and they told you that we said things in opening that didn't come in during trial, and that's true. Strategies change during trial. But remember, we are not the ones under an obligation to put on any evidence. It's not us.
I mean, that's a fair way
We're
to
not
address
under
it,
an
I guess.
obligation to prove it. All right, I'm going to move to motive. The state absolutely did not prove that Kouri's relationship with Josh Grossman was a motive to kill her husband. Yes, they were having an affair. Eric was also having an affair, possibly more than one.
What?
You heard there was a text about an open relationship, and they can laugh about that, but that's what the text said.
No.
I didn't see anything about an open relationship. Did you?
No, do not fall into the I have other uses for your throat trap. Ma'am, you are going to lose the jury trying to make unserious texts serious. You have points that you can make. This is not the point.
And this is what the other guy, Tony, from JD, Ask a Lawyer, that's the part he was emphasizing too. You lose the jury when you stretch things too much, when you try to be a little bit antagonistic with the person on the stand with the neck brace there. It's just not going to work.
Eric was also having an affair, possibly more than one.
There's no evidence of that.
About an open relationship, and they can laugh about that, but that's what the text said.
Ma'am.
You know what? We do not bring this up to make Eric out to be a bad person.
You don't?
It doesn't matter what he was doing in his personal life. That's not the point.
Then why do you keep bringing it up?
The point is that there were parts of Eric's life that he didn't share with people. Just like he didn't share with Cody that he used marijuana, or even that he took prescriptions. The point is we all have secrets, and Eric had secrets.
And that's a fair point.
Mm-hmm.
But back to Josh. The best evidence that Josh was not a motive for Kouri to kill her husband is that after Eric died, she never did get together with Josh. She didn't show up at the brunch that they'd planned to celebrate the closing on the Midway mansion. She didn't go on a vacation with him in April. She never even finished paying for that vacation. Josh told you that Kouri changed after Eric's death, that she was grieving, that he saw less and less of her,
argument.
and ultimately she broke things off. And by the way, if Kouri was as motivated by money as they would have you think, would she really have killed her wealthy husband to run off with the handyman who lived for free in one of her houses?
I mean,
that doesn't fit with the state's theory.
Fair question.
Opportunity. Well, I guess her opportunity was she was the only one in the house. Who else was in the house, though? Who else had an opportunity to take those pills?
Eric?
Eric.
Yep, that's exactly where we're going with that.
4 years later, 10,000 searches, over $300,000 worth of expert witnesses.
There were 10,000 searches?
3 weeks of trial. The FBI, the DEA, Homeland Security, the Summit County Sheriff's Office. They cannot tell you how Eric ingested that fentanyl. They haven't done their job, and now they want you to make inferences based on paper-thin evidence. They speculated on a number of things during closing, and they want to tell you, they want you to do their job for them. Tell them no. Tell them if they're going to charge a person in your community with the most serious crime there is, they better have the facts. They better have the proof. They better have more than speculation and conjecture, because that's their job. It's not your job. One thing I want to point out here, though, is if after looking at all the evidence, you believe that Ms. Richins accidentally obtained fentanyl when she thought she was getting oxycodone, and then Eric took those pills voluntarily and died, that is not intentionally and knowingly. That is not aggravated murder. And if you conclude that, you must find Kouri Richins not guilty. All right, attempted
You should
murder.
have started there.
What is the evidence of this?
Why are you skipping over that point so quickly?
Matthew Throckmorton, the handwriting expert, all he could tell you is that Eric probably did not sign the True Stage insurance policy. Probably is reasonable doubt. And he could
That's
not
a better
tell you
argument.
that Kouri did sign it. They have not proven that Kouri forged Eric's signature. And there was no evidence either way if Kouri had permission to sign Eric's name on that True State's life insurance. I mean, let's be serious. It's the rare married couple who doesn't occasionally say, hey, honey, I'm going to sign this for you. Is that okay?
Ma'am?
But there was no.
He wrote her out of his will, though. This happened. Okay.
Evidence either way. She's not guilty of forgery.
Yes, writing her out of the will, that's a big thing.
Okay.
All right, jumping to the insurance fraud counts, count 3.
She
Count
skipped over
3
that
is
faster than I thought she would. Honestly.
Connected to count 5. Because this count alleges that Kouri fraudulently obtained that insurance policy, and the fraud was forging Eric's signature. They said there was a reversed social security number on there, but the fraud's the signature.
I mean, the phone number, though.
So if the state.
And by the way, folks, please remember to like the video. Likes are free, and subscribe to the channel if you're not already.
It hasn't proven to you count 5, it automatically follows they haven't proven count 3, and you must find her guilty, not guilty on count 3.
Okay.
Count 4 says that alleges that Kouri fraudulently collected the True Stage insurance policy. All that means is if she did kill her husband and then represented something different to collect that insurance, that would be fraud. But if you find Kouri Richins not guilty on count 1, you have to find her not guilty on count 4. The state has not proven their case.
It's an interesting way to attack
They don't
that.
have the evidence that Kouri Richins killed her husband. So instead, they have tried to show you as much evidence as they possibly can to convince you that she's the sort of person who would. I have to tell you, I'm afraid to stop talking.
I bet you are. Cloak of righteousness.
As I stand here right now, Kouri Richins is still cloaked in a presumption of innocence. I don't ever want to walk back to that table. As a defense attorney, that is one of the longest walks a lawyer can make. This entire case is going to flash before my eyes. And all I will be able to think about once I sit down is, what did I miss?
Ma'am, it's not
What
about
did I miss?
you.
What didn't we tell you that you wanted to hear? Did I focus on what you wanted to know? Did we do enough? You're about to go through those doors and into the jury room and start deliberations. Everyone in this courtroom, everyone watching around the world, we all wish we could follow you and listen in. But that room, that jury room is yours. It's sacrosanct. In that room, you get to decide. And when you get in that room and you look at the evidence, if you think that Kouri Richins might have killed her husband, that she likely killed her husband, that she probably killed her husband, you must find her not guilty. Because maybe, probably, likely, very likely, none of these reach that extraordinary burden of proof beyond a reasonable doubt. I'm going to ask you to do a couple of things when you go into that room. First, you might be tempted to go around the room and take a vote for guilty or not guilty to see where you all stand. We ask that you refrain from this. Instead, we ask, talk to each other about where you see reasonable doubt. Also, if Kathy or Alex or myself did something to offend you during this trial, please hold that against us.
Oh, look.
And not against.
There's the self-awareness. This is probably the best part of her closing, honestly. Hold it against us, not our client. If we didn't say something that you wanted to hear, if you were waiting for the defense to if you just answer this, don't hold that against our client.
So here's my final ask of you. When you're deliberating and something comes up that we didn't respond to, will you be courageous? Courageous enough to raise your hand and talk about what our response would be. Raise your hand for Kouri, because you are the last line between an innocent woman and the state. Be courageous. Courage is what this moment demands. The courage to stand between a member of your community and the state and demand that they comply with the Constitution, that they comply with their burden. Do not let them fool you. Do not fall for red herrings. Kouri Richins did not kill Eric Richins. The state did not prove this case beyond a reasonable doubt, and you have the courage to tell them this and find Kouri Richins not guilty.
There is a reason the state provided you in its slides with the cite to every single piece of evidence it argued. We told you what transcript page and line number.
Yes, they did.
We told you what exhibit number. Because what the attorneys say doesn't matter. The evidence is what matters. And there's a reason defense counsel didn't cite you to the evidence. All the evidence in this case proves that Kouri Richins murdered her husband and the father of her 3 children, Eric Richins. There is no other rational explanation for the evidence. And despite all the evidence, Kouri Richins clings to the facade that has enabled her to get away with so much for so long.
Oh boy.
And despite all the evidence, Kouri Richins doubles down and blames Eric. She is intensely ambitious. See through her facade, check her ambition. Do not let her get away with murder.
I think it was like 15 minutes ago that I said, guys, go get dinner, do what you need to do.
The thing is, there's tons of motive, life insurance, running away, getting the actual drugs that were actually used, that were actually was a lethal dose. There's all sorts of things pointing in her direction. The walk the dog letter, all sorts.
Don't worry. We're not going to be live again tonight. I need to just stop saying things because holy moly, am I wrong? They're going to want to sleep on it. They're not going to be back tonight. I said all of the words. And the jury was like, bet. I don't even think they deliberated for a full 3 hours. They got dinner and they were like, we got dinner and verdicts. That is, by all accounts, very, very fast on a long trial and serious counts, which means whatever they believed it probably prior to going into closing arguments and didn't have a ton that they needed to decide. And they're going to read the verdict. Remember, there are 5 counts here: aggravated murder, attempted murder,
Count 1,
insurance fraud.
Aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of aggravated murder. We, the jury, unanimously agree that the prosecution has proved the following circumstance or circumstances.
These are the aggravators.
Count 1 beyond a reasonable doubt.
These will be the aggravators.
The homicide was committed for pecuniary gain, and the homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity.
They found both of the aggravators. Count 2 is attempted.
Attempted aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of attempted aggravated murder.
That's guilty on the attempt.
We, the jury, unanimously agree the prosecution has proved the following circumstance or circumstances regarding count 2 beyond a reasonable doubt.
These will be the aggravators.
The attempted homicide was committed for pecuniary gain. Count 3, insurance fraud. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of insurance fraud.
I imagine it'll be guilty across the board
Count
with
4,
this.
insurance fraud. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of insurance fraud. Count 5, forgery. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of forgery. It's signed by the foreperson. Please have a seat. Madam Foreperson,
That's not
is
easy for
this
Kouri.
the verdict that the jury reached unanimously?
Yes, it is.
Okay, you may have a seat. Ms. Lewis, Ms. Nestor, do you wish the jury to be polled?
Yes, please.
All right.
They're going to poll the jury.
Folks, I'll ask you the same yes or no question, one at a
It'll be
time,
interesting to
starting
hear
on
how they
my
answer.
left, working this way. Front row first. If you could show me your lanyard number as I ask you. Juror number 5, is this the verdict you voted in favor of?
Yes.
Juror number 4, is this a verdict you voted in favor of? Juror number 3. I can't see your number, I'm so sorry. The foreperson, I just need to ask you again, I'm sorry. Juror number 2.
Yes, it is.
Juror number 1.
Yes, Your Honor.
Bruce Rivers, the criminal guy. or the criminal lawyer, that's his name. He's a guy from Minnesota, a defense lawyer.
Sir. Jury number 8.
Yes.
Juror number 7.
Yes.
Juror number 6.
Yes.
All right. We'll set sentencing
Isn't May
for
13th the victim's
9:30
birthday?
a.m. Wednesday, May 13th. We're hereby referring Ms. Richins for the preparation of a pre-sentence investigation report.
I think the 13th
Ms.
is the
Lewis,
victim's
anything else
birthday,
on the record today?
No, Your Honor.
Mr. Bloodworth.
which has kind of a
No, Your
wild
Honor.
symmetry.
Ms. Richins, I'll see you again, May 13, 9:30 a.m. I need everyone to stay seated, follow the instructions of the Summit County deputies.
Wow.
The court is in recess. Travel safely.
Let's take a look at the defense's statement. I saw this on Kathy Russon's X. Law Nerds pointed it out. It looks like a typed out statement, so I'm just going to read the typed out statement. This was earlier today while the jury was deliberating, and I was like, that's a choice. I think I also said it feels like they're trying to get ahead of a guilty verdict. They can see the jury, we can't. So that's what it felt like to me when this statement came out. I don't know if I'll still feel that way, but this is the statement from Wendy Lewis, Kathy Nestor, Alex Ramos, attorneys for Kouri Richins. After 3 weeks of testimony and closing arguments, this case is finally where it belongs, in the hands of the jury. We are grateful to the jurors for the seriousness and care they have shown throughout this trial. They have listened closely to every witness and every piece of evidence, and we respect the responsibility they now carry. For nearly 3 years, the public has heard accusations about Kouri. Those accusations created a narrative that spread far beyond this courtroom. But in court, accusations are not enough. The law requires proof. After 3 weeks of testimony, the prosecution has failed to prove its case. The standard in this country is proof beyond a reasonable doubt. That burden, they say, has not been met. Kouri has maintained her innocence from the very beginning. Over the past several weeks, the jury has had the opportunity to hear the full evidence, not the headlines. Not the speculation, but the facts. We believe in the jury system and we trust the process. Kouri should finally be able to go home to her 3 young boys and begin rebuilding her life. The defense, I think, did what they could with difficult facts. I don't think a different closing would have changed it. The jury was not deliberating long enough for me to think a different closing argument from the defense would have changed it. I imagined we're going to see at some point the defense being like, the jury got it wrong. Maybe not. But we will be back in court in May for sentencing in this case. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to.
So I don't use Discord very much. It's kind of confusing to me. I use Reddit and Telegram much more than I use Discord. Like I said, Discord's like it's not easy to use to me. I mean, I could learn how to do it more because a lot of YouTubers do like a Discord, but it's just not simple. Like, it's confusing to me. I mean, Reddit's just so much easier to use, in my opinion. And ultimately, it's about, if I do it for this community, it's about what's good for this community. And if a lot of people don't use Discord, then it won't go as well. Telegram's not bad. Reddit's not bad, but it's all just another platform, right? Basically, in all that stuff, you get what? It's this. You get a live chat, basically, except on Telegram. Or except on Discord. What did Rooster say? I don't even know. But yeah, definitely remember to like the video. This might be the one and only day that we go over the Kouri Richins stuff. People don't seem to like it as much. It's interesting, Danielle. I mean, I probably should, but we'll see. Yeah, we might do that, Bella, at a point. I mean, I'm not sure who would be here if I started streaming during the day, though. Like right now, it was working well with Nancy Guthrie to go over it at nighttime because Brian and Ashley and everyone, Law and Crime Network, they would basically go over what happened in the day. And then I would go over what they go over. But now that that's kind of wound down, we'll have to see how we do things here. I mean, Ashley and Brian do have a video that maybe I'll go over tomorrow. Yeah, George, see? Not as good. Not as good. The others just what? Don't what? Yes, there's a lot of sassiness on the old Reddit. And you got it, Autumn. It was interesting. I mean, I bet you it's more of a payoff if you watch the entire thing. It's like, for example, in my community here, imagine the payoff it will be if they find Nancy or arrest someone, right? And then going to that trial and watching that trial. Considering everything we've gone over, that would be pretty interesting, right? Have a good night, Crab. But we didn't go over the Richins case in that way, so it didn't really pack the punch here. I could have, but I said moving forward, I probably will do that. And I might be streaming more to be able to do that properly, by the way. So I might do some things during the afternoon, evening, as well as the 10 p.m. Yeah, it's been a long time. I don't know what took so long. Was it all just like the pre-trial stuff that took so long? 3 years is a long time. I mean, she was in county jail for 3 years. I think a lot of people are looking for that one, Bella. The Suzanne Morphew case. Do you know when that starts, Bella? Well, the wheels of the law go slow. Of course, Anne, of course. Problem is, I just don't think, it just doesn't seem like they're close to anything right now in the Nancy Guthrie case. It's losing steam. So the cases we might take a look at are the OnlyFans woman that killed her boyfriend, Nick Reiner, of course, but we still got some more time before that happens. Suzanne Morphew, not till October. Why are there so many pretrial hearings? Just more fodder for the people to watch. I mean, she's basically going to just live her life of the last 3 years, except at another prison that's probably worse. Yes, most likely, Danielle. She's gone, most likely. I would think it'd be shocking, honestly, if she wasn't at this point. Thank you, Miss Kim, for all your help. Same with you, Song Bits. Thanks for modding. And that's the problem, man. They got the mixed DNA from the house, but it's not a good sample. They're going to do genetic genealogy on it, but still not a good sample. So what do you do? To me, it just doesn't seem like they're anywhere close to anything. Even if they're not telling us everything, which they aren't. I mean, Jen Koffendorfer said they could be withholding 99%. But even so, even if they're withholding 99%, they still haven't found her, and they still haven't made an arrest. So even with what they know, it's not looking very good in that case. Yes, indeed it is, Bella. Indeed it is. You want saliva, blood, or semen, and they did not get any of those. Yeah, so make sure you thank Miss Kim and Song Bits for modding. Livin will get a demerit for not being here at all. Uh-oh. Like I said, Kat's got a job at the Chuckle Hut waiting for her. The English Chuckle Hut. Indeed it did, D. And just like we went over last night, Sheriff Nanos, man, he's been wiling out since 2016. Indeed, Rooster. Indeed she is. I mean, Cat went so hard that it even offended Rooster. Oh my goodness. Also, the announcements Thursday night, Dr. Salerno live stream. And I haven't decided really everything we'll be doing with that, but we'll see. We'll see how that goes. Yes, Kat, she's good, but she's going to get a demerit anyway. Just like I've given George demerits before for not being here, but he's here all the way to the end today. Ellie is someone I haven't seen for a minute. No Jolly today either. Now, I mean, he might get voted out though, George. He might get voted out. Dr. Salerno, the author of The Nature and Nurture of Narcissism, Trauma Cognitive Dissonance, and Cruelty by Nature. He's the guy that believes it's more genetic in nature, like psychopathy, narcissism. So that's what we'll talk about. We'll field some questions as well. Oh, okay. That makes sense, Kat. What's going to be impossible? No hype. All right, Kat. We'll see. Well, everyone, about time to rock and roll here. So thanks everyone for joining me tonight. So Song Bits, Kat, Danielle, Miss Kim, George, Rooster, No Hype, Autumn, Anne, Bella. Who else? I'll be back again tomorrow night. Teresa, you have a great night as well. Reggie, I didn't know you were here, but thanks for being here. All right, everybody. Have a great night. Till next time.